Yeah. And then the Tiger game is on the 31st.
Hey, what happened? Did I just? Who did that again? They did that? No, I didn't. That's from arraignments.
They got it funny.
They gonna say I did
Shut
that.
up, that's.
Just Giles, you representing
He's on.
Oliver
He's
again?
on.
They, listen. All right, let me.
Call them upstairs so we get stuff ready.
Yeah, I just talked to her and told her. She doesn't have anything right now. Right. Hey, what's going on with our Tuesday? I think they just got a lot of charges. Look at this. Look at all them
You
charges.
will have to see all that. That's the thing. You need to.
So, intent to murder.
That's next Tuesday.
Yeah, this is next Tuesday, 31st. 31st, and Thursday, 1st, and Friday is the second. Here's next week's docket. You want tomorrow's docket? Judge, do you want, her dockets for next week? Or you?
No, okay, I don't like to go.
Okay.
I did tell her you might want them, so she might have them for you.
She's as good as you.
Here's tomorrow's docket.
Okay. She's back.
Oh, I got Upshaw.
So what you think?
Who do we have Upshaw? Oh, he's our 9 o'clock.
Oh, poor black man got to go 5 or 6 months
Maybe
ahead
it's
of time, so he
waiver.
gets money, right?
Maybe. I don't know.
I just love it. So, okay, good.
Go ahead.
Book five, my man. So you break it in, you bring someone else in.
Good morning, Mr. Upshaw.
Good morning. I'm calling it early because I have a 9 o'clock with the Mr. Bryant. I'm stuck in Ohio. He's going to be there in a few minutes. I was wondering, can I conduct the exam over Zoom or do I have to have Ms. Bates come in?
That's up to you. I mean, if you conduct it over Zoom, then he can't, you're not able to, talk to him, but, if you want to do it that way, it's up to you. You do it either way.
Okay, I have Ms. Bates coming in regardless, Judge, but yes, I'll conduct it over Zoom and she'll be there to assist him. Thank you very much, Your Honor.
Okay, all right, thank you.
He's here.
His client is here? Oh. What?
As long as he has my money.
Yeah, you heard that.
Mm.
Don't be using my name. So when are you gonna go up there? When are you going up there? I should brought Doc.
Oh, upstairs, soon as they get something ready.
This client is out there at 9 o'clock, so he's out there. I don't know why everyone else is up there, or whoever's supposed to be representing Oliver.
Yeah, let's see who actually is supposed to be. For justice. Yeah, what? Right, that's how it should be. Yeah, we waiting on Miss Bates. She said Miss Bates is coming in. But you used to work with them.
Yeah, just so you know. Yeah.
Oh. Mr.
Actually, I
Upshaw,
can
just
go
so you
without
know,
Miss Bates.
oh. Just so you know, your client is here too.
And I don't have to wait on Miss Bates. I'll just I just had her come in just in case that there was a problem there, but I've informed my client and I'm ready to go forward.
Oh, okay. We can bring them in.
Got your witnesses?
We're not okay.
Was that Judge?
You got your
witnesses?
Oh.
You got your people here for 9
I
o'clock,
don't,
is there?
I don't think they're here yet.
Oh, okay.
Oh,
It could be any one of three. I'll go talk to House once.
Okay.
All right.
okay. Trying to come. All right. All right.
Oh, here's your car. At least that's good, at least. Let's get better, dude. That's good.
Yeah, better.
Oh, it looks like it's supposed to be, Carolyn Marsh. Carolyn Marsh.
Yeah.
Courtroom 233. Oh, that's okay. All right. They got one PCC ready.
You got another?
Yeah, yeah. Oh, Lord, can you do me a big favor? Can we take this file to, 438?
Would be Judge Sabrina.
Yeah. That's where the judge is. In the docket. So they can keep this case.
Oh, that's our 9:30.
Yeah, he got another case.
Okay. Gotcha.
Oh, well, actually, you know what? I wonder if I should just keep it.
Why would you keep that? It was going hard.
Do you think they'll come in here first? Because the exam is in here.
If they come in here with some of us,
After.
they'll probably have to, well, and he might do it.
Well,
He's the judge, ain't he? He gonna be the judge anyway, right?
right, that's what I'm saying.
Let's wait and ask.
Maybe no, I asked him, he said, give it to them, but I was just thinking like, they may come in here.
We can send them upstairs. It's all depends on who's moving, him or her. I mean, them or the judge. It would make a difference which, as far as court reporting, which courtroom is in.
No.
It does.
Yeah, then I do it versus,
You said, yeah,
I mean, if it goes, yeah.
for, PCC.
Oh, no, do it in here.
But this is an
That's
exam,
easy.
No, he has a PCC
right? But
with
I was-
Mr. Breed, and he has another case exam with us.
I know, but didn't he say that he was gonna give the exam?
No, we're doing the exam.
Oh,
Then we should be doing the PCC then, because we got the first earlier, right?
No.
They do.
That's the thing, they have the earlier
They're
case.
supposed to.
Why they not doing it?
Yeah, send it back. to
Huh?
them.
Why aren't they doing the exam then? They got.
Well, I asked the judge, he said because he already set the exam, we're just gonna do the exam.
but that's the file for.
So the exam actually should go to Sabrina.
That's what I'm saying. And since she's not here, he's gonna be doing it anyway.
Right, so
Send
I
it
think
upstairs. So send
I can't say send it upstairs.
Sit upstairs, okay.
Is that,
it to their
this
case.
is the file for the exam, right?
No, that's
This is about-
PCC.
Oh, well, that definitely should go
The
upstairs.
exam is with us, so what, so
Oh,
we'll just
well,
send them
you
up
know what?
there.
So he's gonna have to come back down here with an exam.
Yeah.
So if he's not sending the exam upstairs,
No, the
Just
exam
do
we're
the
gonna do.
We
oh,
should
well,
just
then
put it
keep
on
the
our-
PCC here, but, technically it would go up there, generally the exam.
Yeah.
But yeah,
I'll
if
take it
it's
up
just a
there because they
PCC.
probably on Zoom now.
Yeah, take it up there, cause.
What's this?
No, if it's just a PCC, can you just keep it? Why make him go to two different courtrooms for a 5-minute
Yeah,
or,
right. That's what
2-minute
I'm saying.
thing.
We should do everything here, since he's doing it.
I would have sent the exam upstairs.
You want me to go upstairs to see if they on Zoom, and if they not, bring it back?
Tell him he could do the exam up there.
No, the judge said he wants to do the
And
exam.
what we gonna do with that PCC? It's gonna come to us as an exam next?
No, it's going to Debris.
We got two exams by this
Calm
guy.
down, Ty.
No.
Listen, dude. The thing is, if we do an exam and they got the earlier case done. So the thing is this,
Do it
now we do one exam, they go do another exam and he just,
No, that's the
I'll be bothered.
yeah,
PCC.
it's gonna become an exam though.
Yeah,
So
and that's
it's-
gonna be theirs.
It should, all that should be there.
It should all be there,
It's-
so let him
It
do the,
should.
let him
I
do
don't
the
even know
exam
why he
upstairs.
just, that's what he should do, sit it all.
He should send it up there.
He should just, but he
Or bring it
said,
all here. When
I
it's-
asked him, he said, no, we're gonna do the exam and
So they got to come down here, so they're gonna be on Zoom and then they're gonna come here. Come to the building.
see, my thing is, they're probably gonna come here first. Cause of the exam,
What case are we talking about?
Victor Moore.
That's at 9:30, so they should just come up here. And I wonder if they're here upstairs.
Huh?
I wonder if they're upstairs.
No, cause she, the clerk just called and said she only has one ready.
And you know who that attorney is for that case?
Huh?
Uh,
You don't know?
I remember security, I remember the name, but I don't know, I can't put a face with it. For the, Victor Moore, you know who that is?
Hi, this is Carla Judge.
Yeah, she's
younger.
Yeah,
I'm calling to turn your phone.
Well, we haven't even done it.
Hi, you
Our
called us
PCC.
last Friday. How can I help you?
No one showed up.
Nobody's here yet on the
Barry's not
PCC.
showing up, I mean. I think the parties will start off, right?
I know. Mondays usually are slow. Alicia, Alyssa,
Security.
yeah, that's what it is. Says appointed, so. See.
I wonder who's the attorney for,
I can give you our
I'll-
clerk works number and she probably can answer those questions.
It's, Carol Marsh.
Do you have a
March
pen?
is one.
Yeah, I just looked in her file.
And no, does she know she's on it? Golly, this is not like.
She should.
Yeah.
That's one thing about Mondays, it's like everything is like slow start. Let me see what my little son is. This is-
Okay, it's 313
it's a hot mess.
969 2222. Kitty.
I don't think they're prisoners.
I don't know.
He's
I don't
just
know.
so
yet.
happy he can walk.
Oh, he's walking up?
Okay. Sorry,
When you be,
Huh?
would you be happy to?
Yeah.
See, I can do it all.
What?
Why did they do it? What happened to these parents buying these kids walking shoes? You know, we had to wear walking shoes. Even my
They're
son,
better
they're
for your
called
feet.
walking shoes.
Yeah, cause you get these other shoes that are,
They're
they
not.
try to look all stylish, they're not.
Courtroom 233, Judge Giles, courtroom. Good, how are you? Uh-oh. And who is this? Who? Okay, if you're gonna have to go through his attorney, you can't do nothing personal. Do you have his case number? Okay, and he's being arraigned, he was already arraigned, you said? What judge? No, it was not Judge Giles. Judge Giles doesn't do arraignments. Okay, so the case is probably assigned to Judge Giles, but arraignments are mostly, they're mainly done by a
The
magistrate.
boss said the file stays upstairs.
No, that's the PCC, yeah. I could have done the PCC.
Okay, yeah, that's felony arraignments.
Yeah, walk it, they could have done it right there.
Okay, do you have the case number so I can look at it? and
I
get an
asked him, he
idea
said he
what-
wanted it up there.
Or let's do this, what is his last name? Thompson? And what is his first name? Does he have a middle name or a middle initial? All right, come on. Oh, you said Maurice is his middle name? Okay, that's, oh, here. Hold on. This is- Is it assault with intent to murder? Okay. Okay. 305. I just want to make sure it's the right case. All right, let's see. Looks like he was. Yeah. So his PCC is May 30th, yep, in front of Judge Giles. Let's see what it says about the tether. Out. And you said he's still here because he hasn't got the tether back up. Yeah. So my, I don't see an attorney assigned. here.
No, where's Peter now?
Just arranged.
I haven't seen him in a while, it's been 2 weeks, but,
He's in Judge Jefferson.
oh, he's Jefferson.
Yeah, he's been there.
Yeah, well, I know I saw him early on and I haven't seen him. in a
I'm
while,
sorry?
so or something.
Yeah.
He's with Blair.
Well, you're gonna have to contact, the magistrate, because she's the one who set the, bond. Okay, she's the one who gave the requirement. That's magistrate, her first name is Laura, Laura. Her last name is Shante. C as in cat, H as in cat, A as in apple, R Robert, T as in Tom, E as in Edward, and A as in 965-2280. That should be coming. Huh? All right, you're welcome. Yes, I'm Judge Giles clerk. Yes, you're welcome. All right. All right. What do we do? So you said the file stays up there?
Yeah,
Yeah, I figured that's what the judge said, but I was just trying to make it easier.
Yeah, that's what I thought. That's what I'm thinking too.
Yeah. I was.
Oh,
Oh. Oh, well, we could do that exam.
Yeah, we do.
Exam.
Yeah, it's great. I mean, look for those.
All right. So this is Corey Brown.
Have we switched out on?
Yeah, yeah.
On Laurel Court, because he got stuck in Ohio or something.
The court officer was asking, our client asked if his mother.
Yes.
Yeah. Only apartment.
Yeah. Are they in prescription? If they're not prescription, you can. Oh. Okay, no.
Rob was going to see if we can
Oh.
talk to someone.
Ready?
All rise. 36th District Court for the City of Detroit, State of Michigan is now in session with the Honorable Judge Ronald Giles presiding. You may be seated.
Parties ready on Corey Bryant. Calling case number 2356705, the people of the state of Michigan versus Corey Bryant. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault with a dangerous weapon, felonious assault. Count 4, count 5, count 6, weapons, felony, firearm. This matter is scheduled for examination.
Good morning, Your Honor. Ed Wood appearing on behalf of the people, P 86266.
And Randall Upshaw on behalf of the defense, Your Honor, 43574.
Thank you. Ryan, can you state your name for the record, please? Can you put your name on the record, please?
Yes, sir. My name is Jakes. He's been at 6080 with the law and Randall Upshaw.
All right, ready to proceed?
Yes, Judge.
All right, you got the seat.
Before I call my first witness, Your Honor, I would just ask for a mutual order of sequestration of all witnesses, with the exception of my officer in charge, who's present in the courtroom and will not be testifying.
Any objection?
No, Your Honor.
All right, the witnesses testifying today at trial or any time in the future must be the courtroom or be denied that future testimony. That includes YouTube and Zoom. Give exception to the officer in charge.
Thank you, Judge. The people would call their first witness, Mr. Anton Goichai.
Anton, AntonGojzaj.
Yes.
Perfect. Step through
Step
here.
over this way, please. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I will.
Close the door towards you. Pull that microphone down a little bit. One right there. Yeah, pull it down a little bit. Boy shot?
Yes.
That's how you pronounce it?
Yes.
So you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will ask you some questions, and I may or may not ask you questions, all right?
Okay.
You have to answer all your questions out loud verbally using words. You just can't shake your head or say, you have to say yes, no, whatever the answer is, all right? Also, I need you to listen to the question and just answer the question you're asked. If it's a yes or no question, just say yes or no. If they need additional information from you, they'll ask you another question, all right? Now, I have a tendency when we talk about something that, may have been traumatic to us, we tend to ramble. Because we want to get the whole story out. We will say this happened, and this happened, and this happened, this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision, all right? I know nothing about this case. Only thing I know about this case is the defendant's name and what he's charged with. Now, I know your name, that's it. I get all my information from what happens in court. One question, one answer at a time, that way I can understand it, okay?
Sure.
All right, thank you, sir. May proceed.
Thank you, Judge. Sir, could you please tell us your name one more time?
My first name is Anton, last name Goichai.
Mr. Boychai, I'm going to direct your attention back to May 1st of 2023. We're at the location of 21370 West McNichols Road.
Yes, sir.
Is that in the city of Detroit, County of Wayne?
Yes, sir.
What is at that location?
Is my business restaurant,
What's the name of your business?
Bill's Chicken and Waffle.
You said it's yours, so do you own that business?
Yes, sir.
I want to direct your attention to just after 7 p.m. on May 1st at that location. Were you in the building that day, at that time?
Yes.
Okay. And what, if anything, happened there that might bring us into court here today?
There was a customer there that had an order with us. And it was an issue with him regarding, it was on our side, it was a communication error through a credit card machine. It was like, the process, it was not completed. That's what showed on our side with his credit card that he used.
Okay, so let me stop you right there. That customer that had an issue, do you see that customer in the courtroom here today?
Yes.
Could you please point to him and identify him by an article of clothing?
It's shown right there.
No, the customer.
The customer?
That customer that you had an issue with. For the record, you just pointed at an officer.
Oh, no. Oh, no. No. You're not gonna testify. You're not gonna lead them, especially not like that. You're not gonna help them identify anybody.
My apologies, I wasn't trying to do so. I was just-
Well, that's exactly what you did. You just eliminated one person from this room from being identified. And he identified the officer as the.
No, I'm sorry, I apologize.
Stop talking.
Your Honor, with all respect, I think he's made his identification and anything else should be stricken.
I'm gonna need to have a sidebar, Mr. Upshaw. No, let's go around this way.
I can try, did you, what? I'm sorry, I don't want to cut you off, but what was, the court date, the court date? I'm gonna look at it. Oh, it's Bree. The Bree? Okay, so it's assigned to Judge Sabree. And that's for the 26th, correct? All right, what was the person's name?
No further questions for this witness, Your Honor.
No questions, Your Honor.
Thank you. You step down, sir.
Excuse me, I would ask that that last witness stay sequestered from the, any subsequent witnesses, Your Honor.
Yeah. All right, just so, Mr. Upshaw, you're clear, and I want the record to be clear. So we had a sidebar conversation, because of the, well, let's put it this way, because of the continued issues regarding COVID, et cetera, you know, the court itself has always been closed. We restrict the number of people in here. And the witness identified actually the officer in charge as the person who was the customer. And then on the record, the prosecutor corrected him, which the court feels is very improper from the standpoint that, I mean, there's only, well, other than my court officers and myself, there's only one other black male in the courtroom. And, you know, which makes identification in that case very suspect by, because you also said, no, that's not him, it's the officer. So the prosecutor agreed that he would not go forward with this witness, which why he didn't answer more questions, and that he would just you know go forward with any other witnesses he had. I just wanted the record to be clear. All right.
Yes, Your Honor. I just didn't want the witness talking with the other witnesses in the hallway.
Oh, I understand. He's been instructed.
Thank you.
All right, you can call your next witness.
Yes, thank you, Your Honor. The people would call Andrea Djelovich.
Hi, the first name is Andrea, Andrea, last name Djelevic. Yeah, perfect. The state of the witness box, the judge is swearing.
Right there. You can raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, and help you God.
Yes.
All right, you put the door towards you. Elovich. I pronounced that right?
Yes.
You're gonna be asked a series of questions. First by the prosecutor, and the defense attorney will probably ask you some questions. I may or may not ask you questions, right? You have to answer all your questions out loud verbally using words. You just can't shake your head or say, yes, say yes, no, because everything's being recorded.
Okay.
Right? Also, when you ask the question, I need you to answer, listen to that question, answer that question, and stop. If it's a yes or no type question, just say yes or no. All right, if they need additional information from you, they'll just ask you another question. All right. We all have a tendency when we're talking about something that, may have been traumatic, we tend to ramble. And we'll say this happened and this happened, and we'll go on and on like that. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision. Okay? So that's why we proceed by one question, one answer. So I know nothing about the case. I know about the case, the defendant's name and what he's charged with.
Okay.
Now I know your name.
Okay.
All right, I get all my information from what happens in court. Okay? All right. May I proceed?
Thank you, Judge. Ma'am, could you please tell us your name one more time?
Andrea Jelinek.
Jelinek?
Yes.
Ms. Jelinek, I'm gonna direct your attention back to May 1st of 2023. We're at the location of 21370 West McNichols Road.
Yes.
Is that in the city of Detroit, County of Wayne?
Yes.
And what is at that location?
That is my husband and I's restaurant, Bella's Chicken and Waffles.
Now, I want to direct your attention to just after 7 p.m. on that day. Were you at that location at that time?
Yes.
What, if anything, happened that might bring us into court here today?
The defendant was getting angry because, so we had a communication error with the credit card machine stating that
Okay, you
we,
need to proceed, question call for a narrative.
So,
Proceed by question and answer, please.
of course, John. So you were there, you said so you were there in a work capacity, correct?
yes,
And you said there was an upset customer.
yes,
Do you see that customer in the courtroom here today?
yes.
Could you please point to him and identify him by an article of clothing?
He's in the back with, right over there with a black shirt.
Thank you. Your Honor, may the record reflect that the witnesses identified the defendant.
Record so reflect.
So what was going, well, strike that, let me ask you a different question. Why was he upset?
Objection, Your Honor. She doesn't know what's in his mind.
Correct, objection sustained.
Thank you. Did he say anything at the time?
He was saying a lot of stuff. He was pretty angry. What I remember him saying the most is, "Don't make me give you a bad day."
So when he said that, what did you do?
I was on the phone with the credit card company trying to figure out if the transaction went through. So he was acting, screaming, yelling, and I wasn't able to, I was on the phone concentrating with the person on the credit card, with the credit card company. So I really didn't say too much to him.
So what was he screaming and yelling, or who was he screaming and yelling at?
My husband was right next to me. My husband was trying to calm him down, like, can you calm down? We're trying to get on the credit card
You can't say what
machine.
someone else says. Other than the defendant.
So while your husband is speaking to him, or what are you doing?
I'm still on the credit card machine, credit card company, trying to answer their questions.
So,
They're asking for his last four of his
You
credit
can't say
card.
what someone else says. And listen to the question, answer the question, and stop. Okay, one question at a time, please. I know it can be a little
Sorry.
difficult. It's all right. See my question, answer, please.
does the arguing or does the yelling by the defendant ever end?
No,
What if anything happens after you're on the phone with the credit card?
he turns around and pulls out his gun and goes towards the, front door. And he is saying, don't make me give you guys a bad day. And he like walks out in front of the front door.
So let
He
me stop,
still continued to talk, but I don't know exactly.
okay, so let me stop you right there. So you say he turned around. Where was he facing before he turned?
He was facing us, then he like walked, like he was facing us talking, and then he like turned around, pulled out his gun, and then started to walk and turn back around to us.
So when you say us, who are you with at the time?
I'm on my left, my husband is in the middle, and my daughter was on the right side,
So
where's the computer,
what's your husband's name?
Anton Goichai,
And what's your daughter's
Elena Goichai.
So are you, the three of you standing, kind of in a row then?
Yes,
Objection, Judge. He can't give her an answer. He's leading again.
Yeah, you're leading like,
I'm just clarifying, because she said they
No,
were standing
no,
next to one
she
another.
said that she was standing there. She didn't say where they were standing. You said you were standing in a line together.
My apologies, I thought I heard her say to my left and to my right, so I was just trying to clarify for the record. So where in the restaurant are the three of you?
we are.
Objection,
in
Judge. She asked and answered. She stated explicitly where each individual was standing.
Well, a second ago, they-
No, also because you objected to how the question was phrased. I'm gonna allow him to rephrase it and ask the question. Go ahead and answer.
So where in the restaurant were the three of you still?
I was standing in front of the computer system next to the drive-through window. My husband was in front of the computer system that is in front of like where we take the orders, and then my daughter was right next to him.
So you said you saw, the defendant, you said you saw him pull out a gun. Did you get a close look at the gun?
Yes, it was silver pistol.
A silver pistol?
Yes,
So what if anything did you observe him do with that pistol?
he pointed it at us, at myself, my husband, and my daughter, all three right there.
How did you feel when he pointed that gun at you?
Scared.
What did you do, when the gun was pointed at you? What did you do?
Honestly, I just froze.
No further questions, Your Honor.
Russell.
Excuse me, ma'am, but when the defendant came into the store and placed this order, you were not there, is that correct?
No, I was not.
All right. And when you received the phone call from your daughter, you drove there from another location, which took you approximately 15, 20 minutes to get there?
Yes,
And when you got there, the defendant wasn't trying to attack anybody or pound on the glass or get behind the bulletproof glass, isn't that correct?
yes,
Okay, so you and your husband went behind the bulletproof glass and engaged in a conversation with the defendant, correct?
yes,
And he showed you his phone where it showed that he had paid for the food, isn't that correct?
he showed me a text message.
Okay. And in fact, the hour after this started, you canceled his payment, isn't that correct?
No, I did not cancel anything.
All right, so at this time, after about the defendant being in the store for about 30 minutes, he turned around and started walking out of the store prior to pulling any weapon, isn't that correct?
He pulled a weapon inside the building, but he pointed the weapon when he got to the front door.
Okay, and did you hear any comment regarding someone locking the door?
No,
Did you hear any, he never said or made a threat that he was gonna shoot you or harm you, correct?
he said, I'm gonna give you a
Yes or
bad
no,
day.
ma'am.
No,
Okay, he never threatened to shoot you never heard him threaten to shoot your husband or your daughter, correct?
no,
Okay, now Did you, without saying what he said, did you hear your husband say any words with a hostile nature to the defendant?
No,
Okay, so your husband was in a nice, quiet, cordial manner, correct?
yes,
All right, so the defendant, after that amount of time, or half an hour or so, he started walking out of the store, and you said he made it all the way to the door, correct?
he was in front of the door, yes.
Okay, and all this time that the defendant was talking with you, he was moving his hands around, making gestures while he was up at the glass, explaining himself avidly with his hand gestures, correct?
Yes,
Okay, and even when he was just trying to explain to you what was going on, his hands was constantly moving at you, pointing to you, pointing to the phone, using his fingers as much as he was using his words. Isn't that correct?
yes,
And when he got to the door, he made it all the way to the exit sign, and that's opened the door, and that's when he turned around and faced the counter. Isn't that correct?
yes,
And when he turned around and faced the counter, he had his gun in his hand, correct?
he had it in his hand, yes,
Okay, but he was still talking, moving his hands around just as he had been doing all that day. Isn't that correct?
no,
And he never told you at that point that he would shoot you again, correct?
he said, I'll give you a bad day.
And he
No,
never
you-
took his arm and
Hold on,
pointed.
hold on, hold on, hold on, hold on. Need you to answer the question that you're asked. All right, not say what you want to say. Okay, thank you. Go ahead.
And you know what I mean by a 45-degree angle, don't you, ma'am?
Yes,
When your arm goes straight out, it like I'm showing you right now, your arm goes straight out like so, correct?
yes,
That's what he never did that, did he?
yes, he did.
He put his arm at a 45-degree angle, and I'm just asking you, because you have an audio and video there, correct?
I have video, no audio.
Okay, now you saying under oath that you positive that he put his arm out at straight out forward at a 45-degree angle? And you testifying under oath.
As far as I remember, yes,
Okay, now if you don't quite remember, you're kind of speculating, but you're not quite sure, correct?
I'm not sure.
Okay. And then he walked out the store, correct?
Yes,
And called the police, correct?
call the police.
And he waited there for the police to arrive outside the store on the other side of on the exterior sidewalk area of the store, and just stood there and waited for the police to come. Isn't that correct?
Yes,
Nothing further, Your Honor.
No redirect, Your Honor, thank you.
Okay, I got a couple questions. At the point where you said the defendant walked to the door and turned around and he had a gun in his hand, you said you were by the drive-through window.
yeah, our place has a drive-through like window, and then there's a computer there. It's a small place, so there's two computer systems, and I was on the phone by
Okay,
the.
no,
Yes,
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 you were by the
drive-through window,
drive-through
yes,
window.
yes,
You said your husband, Mr. Anton,
court check, yes,
yeah, was, this would have been in where the cash register is, the other computer.
Right.
In the front.
right, yes,
Okay. You said your daughter, Helena,
yes,
was standing next to him
on the other side.
on the other side.
Mhm.
Okay. How far are you away from them?
I mean, very close, not like,
How? 2 feet, 5 feet, 10 feet?
maybe two, maybe, yeah, like 2 feet.
Now, you said that the defendant put his arm out straight.
Yes.
Okay, so what was, in your opinion, what was the gun pointed at?
I wanna say all three of us, I mean, we were very close to each other, so I can't really,
So you don't know who it was pointed at?
at that moment, I just like froze, so really honestly, I was right next, we were all kind of together, so.
I mean, he was pointed out straight, and he's holding it there,
And
correct?
he's holding it
Oh,
and.
just listen to my question, answer my question, we get through this whole like. Okay, I know that you'd be very emotional. Okay. He was just holding it there, correct?
He was holding it and talking.
And talking,
Yeah,
okay. So was he moving? No. All right, any questions based on my questions?
Briefly, Judge, if I may.
Yes,
When you say he had the gun straight out and he was pointing it, and you're saying you as collector. So when you were looking at the gun, were you looking at it straight down like I'm looking at you? Or were you seeing like one side or the other of the gun?
say straight, like as if I'm looking at you.
You were looking straight down the
Yeah.
barrel of it?
Yeah.
When did you observe the defendant move that gun at all after it was pointed at you?
I don't remember, I don't remember.
I have no further questions, Judge.
any further cross?
Yeah, Sean, just briefly, 2 points. Ma'am, you contradicted yourself a moment ago when you
Okay,
said,
I'll
rephrase.
Thank you.
At one point in time, you informed the court on cross-examination that you were not sure if he pointed his hand straight out. Isn't that correct?
He pointed it as far as, yes,
You stated that you were not sure whether his arm was at a straight out 45-degree angle. Remember that question?
as far as I remember, that's what I saw, him pointing a gun. Now, I didn't pay attention if it was 45-degree angle or not, but I saw him pointing a gun.
And when he had this gun, was he halfway in the door jamb of the
He was halfway more inside than outside, yes.
but he was in the doorway, correct?
He was at the doorway, yes. More inside the building than he was outside of the building.
And he continued and he walked away from you, correct?
Yes,
He never approached you at that point, correct?
right, yes.
And this whole time that he was in that doorway, before he stepped out the doorway, I would say it was about what, 1 or 2 seconds?
I would say so. I'm not sure how many seconds it was.
Nothing further, Your Honor.
Nothing further, Your Honor.
All right, thank you, ma'am. You step down.
And the people would rest, Your Honor, no further witnesses.
Fence,
No witnesses, Your Honor.
all right. Motion,
Of course, Your Honor. The people will move to bind over on counts 3 and 4, assuming 4 is the correct felony firearm that connects to count 3 here. Your Honor, as we heard from Ms. Jelovich, she identified the defendant in this case being a customer at a restaurant that she co-owns with her husband, Anton. And after some disagreements, seemingly over a credit card dispute, the defendant pulled out a firearm and pointed it at her. And as we heard from her testimony on redirect, she says she was looking straight down the barrel of that gun, Your Honor. So people believe they met their burden for felonious assault on Miss Andrea Jelovich, or Jelovic, don't mean to mispronounce that. But, and we would ask for the bind over on that count and count for the accompanying felony firearm.
Motion.
Yes, Your Honor. Your Honor, what she testified to was that he was in the store for approximately at least 30 minutes. He never attempted to, he never said he was gonna kill nobody, shoot nobody. He didn't have the gun out for that whole 30 minutes while argument seemed like it erupted, a conversation about him paying for his food. At one point, Judge, she said he turned around and started walking out of the door. When she testified that he was always talking with his hands, moving his hands back and forth. As he moving his hands back and forth, as he's walking out the door, she says he pulls his pistol as he's going towards the door. And I asked, how long did that take? Either 1 or 2 seconds? She said, yes, somewhere around 1 to 2 seconds, I'm not sure. And he walks out of the door. He never said, I'm gonna shoot you, I'm gonna threaten you, or anything of that nature. And she admitted that all the time he was talking, even without the gun, he was constantly waving his hands around and things of that nature. I asked her, was she positive or sure that he pointed his arm out at a 45-degree angle? She said, no, she wasn't sure. Then she changed the story again back and forth, but she had originally stated, I'm not sure if he pointed. So I asked the duration of time in which this occurred, 1 to 2 seconds. He immediately walked out the store and called the police and waited for the police, or just waited for the police out there until the police arrived. Judge, he never said, I'm going to shoot you. That was positively clear. He never made a threat of harming. He did say, I'm going to have a bad day, and that's, you might have a bad day. And he called the police and told on him. He was just subsequently arrested. But he called the police, he made his complaint, he waited outside, the police arrived. Judge, I believe the proper charge here is brandishing. He didn't, he never approached her. He never tried to, there is thick bulletproof glass throughout. He never tried to injure anything. We know that. Judge, so she never said she moved because it's multiple bulletproof glass, as she described, between her and there, and he just walked out the door. Thank you for your time and your patience, but I think the proper charge is brandishing.
I would respectfully disagree with Mr. Upshur. I don't believe the correct charge is brandishing, Your Honor. Pulling out a firearm, having it present, pointing, as she testified on redirect, pointing, she was looking straight down the barrel of that gun, and then saying, before that, you're gonna have a bad day, or someone's gonna have a bad day, something to that effect. Those two things coupled together, Your Honor, I don't believe the correct charge is brandishing. I believe it's felonious assault here. She was looking right down the barrel of that gun, Your Honor, and people believe they met the verdict.
And Judge, I'm assuming the prosecutor agrees to the.
Mr. Upshaw, there's no further argument.
Yes.
This Bird gets argument, you get argument, he gets rebuttal. All right, thank you. All right, for having heard the argument and testimony classes as follows, that on May 1st, 2023, approximately 7:00 p.m. in the area 21-370 West McNichols in the city of Detroit, a restaurant, Bella's Chicken and Waffles. Ms. Andrea Belichick wasn't present originally, but then showed up there as a restaurant she owns with her husband. There was an issue regarding a problem with the credit card that belonged to the defendant as to whether or not the order was paid for or not. She was originally, I guess, somewhere else and then came to the store. Say the defendant was angry, yelling and screaming, made a statement about several times about don't make me give you a bad day. That he never directly threatened to shoot anyone, but that he was making this discussion while having this discussion, or yelling and screaming, if you want to call it a discussion. He was using his hands to talk, waving them around, etc. He then turned, started to walk towards the exit, got to the door, turned back around. He had a gun in his hand. He raised that hand and pointed it in her direction. Now, whether or not the defendant at that point was still just using his hands to to make his point as in speaking, using his hands when he speaks, that's a question of fact. Or whether he was pointing it to threaten her, that's a question of fact. So the court finds that the felony in count 3 and 4 did in fact occur in the city of Detroit. Probable cause exists to charge this defendant. Bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 5th, 2023 at 9 o'clock, and bond is continued.
Thank you, Your Honor.
Thank you, guys.
It's Blunt. You wait on.
Hey, can I put your phone number, please?
So it's on all charges?
No. I'm gonna need the dismissal on count 1 and 2 and,
Oh, yes.
you can do it in a
Right,
minute.
yes, right here.
Those are the ones that were dismissed.
Oh.
Katie is on paper more.
What?
You know what?
No, he might be upstairs.
Yeah. Check 438.
Oh, let me call. Hold on, she called me.
Hey, hold on for a second, she's gonna call up there.
Cause she called me.
She just left from up there. She said he's not up there. either.
Oh.
Would he have,
Hey, girl.
did he have a couple on Zoom? No, she had. Zoom.
I could take that file up there.
So. Okay. We just, yeah, we just finished the exam, so, he's talking to an attorney right now. So did Victor Marshall?
Oh,
No.
you got city council in you guys.
Do you want me to go double check? Or 438, right?
Yeah, I go up there for you, because, I'm going up there, but if he's not up there, it's gonna, she has to talk.
Yeah.
He didn't show up on Zoom, matter of fact.
No, he's homeless with mental
Yeah.
health.
Oh, so he was-
Yeah, so I don't even think he has a phone or an address.
Okay, great. All
It's
right.
also on books.
Oh. Yeah, I did. All right, girl.
How you been doing there?
I'm sorry.
How are you doing?
Well, it don't look like he's up here.
Yeah, she said he's homeless, right? And doesn't have.
Well, Victor Moore is homeless? Are you his attorney?
Yes.
Oh. Okay.
Yeah.
Great. So I wonder how, because he has a PCC upstairs, honestly, he should probably just adjourn this exam with that PCC and then they'll be together.
Is there another case?
Yeah,
What did you do upstairs on the PCC? What did you do?
she don't even know. He got a PCC
Weren't you there
upstairs.
with them? Were you up at 438?
No, I just did an exam at Ronald Jefferson, so 439.
I
But
mean, 439.
yeah.
No.
but
No,
it's agreed.
438.
438 is
Yes, agreed.
Moore's other case.
Last time I spoke with her, she said that it was transferred, all his cases were transferred to.
No, they have the older case.
Oh,
So they're supposed to go to, her. But she has the older case. But Judge Giles was gonna do the exam that we set because he already set it for exam.
I wanted to know.
But I'm wondering,
Judge Giles, yeah.
the
Did he do anything?
PCC, we could just send this one up and then she She can send them both. I mean, it would save the case.
That's fine, whatever makes it
It
easier.
would give you time to find them again.
Yes, sir. Who are you? LeVon Jones, okay, have a seat outside with you, what you said. No, that's you, man. Thank you.
Because he had. I don't know.
You know, I haven't seen so many people come up with it.
Because he had to be just arraigned on the other case, on the PCC.
Come here. Why is your man coming to
Hey, don't be like that.
Yeah, I mean,
All right. Parties ready, I'm Victor Moore. Calling case number 2356768, the people of the state of Michigan versus Victor Moore. Defendant is charged with count 1, breaking and entering a building with intent. Count two, larceny in a building. Count three, breaking and entering illegal entry without owner's permission. Habitual offender, second notice. This matter is scheduled for examination. Defendant has failed to appear.
Good morning, Your Honor. Remind who's on behalf of the people, P82800.
Good morning, Your Honor. Alyssa Segura on behalf of Mr. Moore, P86432.
All right. Any contact with your client?
No, Your Honor, I have spoken with his aunt as well as his sister. Both of them expressed that he is homeless and struggling with mental health issues. I have tried getting in contact with him multiple times in other ways, and I've just been unsuccessful, Your Honor.
People who break me.
All right, David, shall enter any bond previously submitted shall be forfeited, the bond set, 30,000 cash.
Thank you, Your Honor.
Thank you. Motion to start our, PCC.
No, I just called, well, I called when the exam was going to have them, check on them, sign.
Oh,
Yeah,
all right. We'll do the other one.
that's strange. Nobody, neither one of our PCCs.
That's usually don't happen, we usually have.
There was no discussion.
Are his glasses prescription? Are his glasses prescription? They are? Yeah. Oh, I thought you had some.
You know, took him was Mr. I think, who had the wrong case in the courtroom.
Oh,
It was
Taylor.
right here.
what was it?
Right there, she's screwed.
Ready?
Are we ready?
Is
First
Green
back
on?
in session. And just fill it out, yeah. Discuss it.
Parties ready on Levon Jones, calling case number 2055177. The people of the state of Michigan versus Levon Jones. Defendant is charged with count 1, license, documents, plates, forgery. Count 2, identity theft. This matter is scheduled for examination.
Good morning, Your Honor. We'd like to move on behalf of the people.
Good morning, Ronald, with the DSP 85665 on behalf of Mr. Levon Jones, who is present in the courtroom. Mr. Jones, if you could state your name for the record.
Oh, wow, just like,
Thank you.
okay, thank you.
Judge, at this time, the people are unable to proceed, that we did not have any discovery and turnover.
And Your Honor did sign a discovery order, I believe, last Thursday, the 18th, and that was provided to Mr. Wyrie via email.
People move to dismiss.
Matters dismissed.
And then wait for the attorney outside, we bring papers out here. It's called. Have a seat out there. He needs to come on. He can probably just come. So. See. Do it.
Good morning, Ms. O'Mara.
Good morning. I was just spot appointed to Demetrius Logan.
Okay, he is on too.
Okay, I haven't spoken with him. Is there a phone number for him?
You want me, I do have a phone number. You want me to put you in a breakout room?
Yeah, that'd be fine too.
Okay. All right, here we go. One. Mr. Logan, I'm gonna put you in a breakout room with your attorney. Please accept the invite.
Okay. Okay.
You see it?
Did you get some info, on Miss March, or she said she got?
I called, reassignments.
Yeah.
Yes. 5323.
You don't want me after that clown show, I just go out. That's good.
Hello?
O'Meara, I'm sorry, Miss O'Meara,
Yes, ready.
did your appearance, please? You just called your case.
Oh, I didn't hear that. I'm sorry. I don't. This Attorney Catherine O'Meara, P 53823, on behalf of Demetrius Logan.
All right. Mr. Logan, can you state your name for the record, please?
Demetrius Logan.
Thank you, sir. Mr. Logan, so you know in the future, I don't do T-shirts in my courtroom, even on Zoom. So when you come into court, please wear a shirt with a collar, all right?
Yes, sir.
Thank you, sir. All right, Ms. O'Meara, you asking for an exam?
Your Honor, I was just spot appointed. If the court would give us another probable cause conference so that I can get the discovery and talk to Mr. Logan about the case, I would appreciate that. Otherwise, if the court wants to set the exam, I just ask for a little more time so that I can get the discovery, talk to Mr. Logan prior to it.
Any issue with her getting the discovery today?
She can get it in the next 20 minutes, John.
All right, you'll have the discovery in the next 20 minutes. So I'm gonna set this matter for exam, May 30th at 9:45.
On what? No, I'm starting a jury trial that day at Frank Murphy, so I can't do that day.
How long is your jury trial?
Probably 2 days.
June 1st at 9 o'clock?
I have several matters in Macomb County that day. Could we do the second? I will be I have 2 things at Frank Murphy that day, but I could do it. I'll be at least in Wayne.
June 2nd at 9 o'clock? Anything else?
Can I just ask
yeah.
that the prosecutor forward me the discovery?
Yeah, they will do that.
Thank you.
Thank you. All right, that concludes the hearing.
Thank you, guys.
client yet?
Your Honor, I called him and he was stuck in traffic. I advised him to pull over and join the Zoom as it is going to be a motion to dismiss by the people, and he wasn't going to be able to make it to court within a few minutes.
You on Zoom?
Yes, he is, Judge.
You know, all right. That's fine.
It's official.
I can't be in no
Parties
meeting.
ready? Parties ready, I'm Rashawn Woods. Calling case
Rashawn
number
Woods,
Mr. Woods, just hold on for a minute, please. Just hold on.
excuse me.
Just hold on. Don't say anything yet.
Calling case number 2356755, the people of the state of Michigan versus Rashawn Woods. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This matter is scheduled for examination.
Good morning, Your Honor. Adam Bookbuck, appearing on behalf of the people, P86266.
Good morning to Your Honor in the court. Veronica Walrad with NDS P85665 on behalf of Mr. Rashawn Woods, who appears in Zoom. Mr. Woods, if you could state your name for the record, if possible, turn on your camera.
Mr. Woods, state your name and turn on your camera, please.
Rashawn Woods.
Turn on your camera, please. Thank you.
Yes, Judge. Today's the day and time set for
Hold
examination.
on. This was set for what? Mr. Woods, your matter was set for 10:30, 10:39. All right. Well,
Yes.
Mr. Woods, I don't do t-shirts in my courtroom, all right? When you come to court, please wear a shirt with a collar, even on
Yes,
Zoom,
sir.
all right?
I apologize, Your Honor. I've been.
All right, thank you.
Okay.
It's all right. Thank you. All right, go ahead.
Thank you, Judge. The people would move to dismiss this case in the interest of justice.
The defense has no objection.
All right, matter is dismissed.
Thank you, Your Honor.
All right, thank you, Mr. Woods.
You're free to log off, Mr. Woods.
Okay.
I'll support. Is that 10:30, Rick?
Nobody's on 10:30.
Good morning, Your Honor, if I may. I just got spotted signs, so I'll be checking in on Lee Quiz.
Oh, that's Attorney Davenport. On Oliver,
Yes, Lee Quiz Oliver.
all right.
Hold on just a second.
Okay, parties ready on Lee Quiz Oliver. Calling case number 2356394, the people of the state of Michigan versus Lee Quiz Oliver. Defendant number 2 is charged with count 4, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Bookbuck, appearing on behalf of the people, P86266.
And good morning, Your Honor. Curtis Davenport, P82678, on behalf of Mr. Lee Quiz Oliver, who I do not see is present, but I do not know whether or not he's in custody either, Your Honor.
All right, waive his appearance for the purpose of this hearing.
Yes, I'd like to waive his appearance for the purpose of this hearing.
Thank you. Court will do so. Set this matter for exam. Available May 30th at 9:45.
Actually, I won't be. Oh yes. What time did you say?
9:45.
Yes, I get it 9:45. That sounds good, Judge.
All right.
Like I
And
said, I've been spot assigned, so I haven't received discovery, and I'll send a discovery order over as well.
Yeah,
Okay.
Mr. Davenport, can I trouble you for your P number? That's the quickest way I can find the defense attorney's email address.
Yeah, no problem. It's 82678. I can put the email address in the chat if you'd like to.
Sure, yeah, if you'd like to do that just as a safety measure, I usually just get them off the state bar. So as long as your email on the state bar is correct, that's the one I'll send it to.
Okay, all right, that's no problem.
Thank you, Mr. Davenport.
all right. All right. Thank you, Mr. Davenport.
All right, thank you. Have a good day. Yep.
You too now. Take care.
Hair grown out, beard.
Well, yeah, I haven't seen him in a while.
Yeah, I haven't seen him in a while either.
Oh, that's funny. All right, so what we got next?
Shots, he showed up for his case.
Wow.
Janice, that's right. Attorney Janice.
Oh, Comer, his attorney was here. Today.
Who, Cromer's attorney?
Yeah.
He just stepped outside. I think it's not one of the prosecutors.
Oh,
Raymond's gonna wait to see if she.
does he know his, Mr. Comer's not coming
I
up?
think Rob.
You told him?
He knows, Raymond's gonna wait to see if any witnesses show up, to see if it's gonna be dismissed.
Oh, okay.
But nobody's here on the 10:30, the yes attorney or.
Courtroom 233.
Pretty much go,
Yeah,
oh, a month and a half, wow. They go,
A month and a half.
yeah, they gonna be lost.
Oh. No. Oh, okay, all right, I'll let him know, all right. Judge, they got a dismissal and a hold in 438. Ready.
Judge, you need to wear your glasses when you say it.
Oh, sunglasses.
What did you got?
And a leather jacket.
Yeah, perfect. Yeah. Black guy, we're basketball, football.
Who, me?
You see, now you're talking.
Yeah.
Golly.
I guess I'm not used to that. My husband don't talk about sports like that. Not like that, you know.
I guess the 11:15 is gonna come. So did he say he would notify him if he wasn't gonna try?
That's true. That's true.
Oh, yeah, he did. You're right. So it looks like it is gonna hold. Maybe he got what he.
Unless he played the last minute try to get some.
You're talking Beasley?
Yeah.
Yeah, too bad.
Yeah.
Beasley and Ruff. But Ruff was
Oh, they're
just
together?
okay.
Oh, they're together.
All right, I'm hungry. So what I need to get more chips. What else?
Those nuts.
All right, some more of these too. Got a lot of these things.
Why is those some just
Huh?
scratch?
You said what?
They might be what's called shelby this thing. And the nuts, those nuts are good.
One.
What's cranberry?
Oh, this one's the,
Those are good too, but cranberry.
these are the cashews.
Cashew or almonds.
all these.
Yeah.
These are, you haven't had these? I see nobody open them. These are cashews, almonds, and macadamias. Macadamias.
Pretty soon they'll probably come out with my man Ron got the.
So I guess they're like these, but instead of the cranberries, they're macadamias. Who's calling my telephone? Oh, Mr. Cripps. Mr. Cripps got something today? Courtroom
Yeah, he got
233,
something.
Judge Johnson.
Remember the two? 11:15?
Hey, Mr. Cripps.
Beasley.
Oh.
Yes, we were just talking about that. Yeah, so the co-defendant came in, Friday and got arraigned, so I don't know how the judge is gonna do that because he wasn't initially started on it.
He didn't get arraigned.
Yeah. Yes, he did.
He got escapism.
That's the same thing. It's
And we-
arraigned on the case.
And we said that he's gonna be here for that.
Oh, yeah, that's right. Yep. Okay, all right, Mr. Cripps, all right.
You'll definitely be back to that.
So, a lot of.
Yeah, right.
So Mr. Cripps is at Frank Murphy, they got a lot going on because of flooding at the jail, they can't bring prisoners.
Oh, man, it's flooding over there too?
Yeah. Really? Well, not flood, but the prisoners.
Oh, the
No,
prison.
they can't get the prisoners over.
Right,
They can do their Zoom cases. They can do them.
they don't have Zoom over there,
They, or they,
I don't think so.
what was this day that they did?
no.
At 9 o'clock, when we like wave them over or.
Oh, bound over,
Bound over.
the AOI days?
Yeah. That's really.
Oh,
We got-
his might be a trial order.
Hopefully that guy. Prosecutor.
Well, we did outside, he was looking outside.
Cripps was trying to find out, did we hear anything from the prosecutor? Cause remember, he was like,
Supposed to call in case he didn't. I think he has something else.
Young lady out
I don't know.
there. Yeah.
Oh, not yet, okay.
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 Mhm.
So that must be registry that's flooded over there.
Must be. That place is.
And you over to tear it down.
Yeah.
Don't worry about it.
He'll take care of it.
Yeah. But has he got any help here? Cause he was sick there for a while.
He was.
All that,
He was
all that
struggling.
money don't mean nothing if you can't.
You done had headquarters for a long time.
Yeah.
All them days.
He's just waiting for everybody to clear out so he can just clean it all.
But you know, the interesting
How
part
come he
is
ain't bought us?
his health.
Next. Yes, help, yeah.
I wonder is his health long lasting long enough to make his dream a reality?
Cause you know, he made his dream a reality down in Cleveland. He did the flats and he, bought Cleveland Cavaliers
He
and all
ain't
that.
getting no younger though.
Yeah.
And if that's the case, then what's gonna happen to Detroit? With all this property that he done bought up, what's gonna happen? The same thing happened with the image.
Their sons take over and mess it all up.
It'll be okay, trust me. It'll be okay.
I don't know, Kim, I don't know if I can trust you or not.
Yeah.
Illich had a whole bunch of plans too before he died.
And
And the son said, nah, I'm going to Vegas.
we have winnings, baseball, hockey was doing coming.
And the Fox Theater done went downhill.
Oh, you think?
Oh,
I
I
haven't been
know,
there in a while.
I know, you don't wanna go there.
Seriously? Oh,
Oh, that was one of the most beautiful place in the city of Detroit.
He made it, he refurbished it, it was beautiful. They don't even hire security in there when they be having all those concerts.
Huh.
They tearing that place up, man. All they do is sit there and smoke weed during the whole concert.
Oh, God.
Remember they used to hire off-duty police officers to be in there? No more.
No more.
The ushers volunteer and that's who the security is.
You better get that together. That's gonna be gonna lose.
They don't care.
they don't have security? Oh, I don't believe that.
They're supposed to build all those, apartments and complexes over there by the Little Caesars Arena. He didn't do it.
Oh, there's a lot going on back there.
Now it is.
Yeah.
How long ago that's been since Little Caesars Arena been open? And that was a promise that they made when they gave them all the tax money for Little Caesars Arena. But Mike Ellis' daughter used to work with him hand in hand. And she probably would have made good on it. But I don't know him, but I hear that the son went to the mom and said, hey, this should be me. Mom said, you're right.
I would be at,
I don't know who Dan Gilbert got. We got any more kids?
his son.
Well, one of his sons, the one with the health condition, just died.
What? Seriously?
Yeah.
I might have heard that. I might have heard that.
The one that used to be at the draft?
Yeah.
Yeah.
Oh.
Wow, I didn't know that.
I don't know how many kids he got.
Are we on mute?
Yeah.
like they
Morning, Judge.
Good morning, how you doing?
I'm blessed, yourself?
I'm good, I'm good.
All right. Parties ready on Aaron Comer. Calling case number 2356715, the people of the state of Michigan versus Aaron Comer. Defendant is charged with count 1, weapons, firearms, discharged from a vehicle. Count 2, weapons carrying concealed. Count 3, count 4, count 5, assault with a dangerous weapon, felonious assault. Count 6, count 7, count 8, count 9, weapons, felony firearm. Count 10, operating impaired. Count 11, failure to stop after a collision. This matter is scheduled for examination.
Good morning, Your Honor. Remax on behalf of the people, P82800.
Respectfully, Judge Jihad Kadafi, 82492, appearing on behalf of the defendant, Mr. Comer.
All right, it's my understanding that we could not get Mr. Coleman's body from the Wayne County Jail because of some problems they're having with the building and flooding or whatever. Unable to transfer. We just need to set a new date.
Yes, Your Honor.
So. Are you available 10 o'clock on May 30th?
May 30th, Judge, 10 a.m. would be perfect. I'm already here.
Okay. All right, anything else?
Thank you, Your Honor. We'll see you on the 30th. Have a great weekend.
All right, thank you.
Yes.
Mr. Braxton,
Yes,
did you hear the date?
yes, for May 30th.
Thank you, Mr. Braxton. We'll send you a follow-up subpoena, and that will be delivered by a Michigan State Trooper, okay? You can log off.
Okay, thank you.
He's the
That's the witness?
He's the victim on the case, yes.
Is there any reason he's not testifying in person? Or he was just called in?
He was just called in. I just wanted to make sure that it wasn't,
Oh.
I just didn't want it to get dismissed, Your Honor.
Right.
Thank you, Mr. Braxton. Appreciate your time. You can go ahead and log off.
Okay.
Oh, Judge, that last one, that's for the exam at, 11:15 with the two co-defendants. Yeah, prosecution.
We'll do the last one that comes up.
Yeah.
We're gonna get Morrow.
Yeah, Mr. Miles is, Cadius.
Yes.
Calling case number 2259137, the people of the state of Michigan versus Juwan Morrows. Defendant is charged with Count 1 and count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for examination. Defendant has failed to appear.
Good morning, Your Honor. Ed Booklet appearing on behalf of the people, P 86266.
Good morning, Your Honor. Chester Jeanette, P83295, representing Mr. Jawan Morris, who is not present in the courtroom.
Get in contact with Mr. Morrow?
I haven't, Your Honor. His phone number goes straight to voicemail. I tried to email him and call him off his email through FaceTime, but I haven't had contact with him since 6:30.
The people motion for case is adjourned.
All right, if you show interview, I'll give you 60 minutes to report, if mine said 30,000 cash.
And Your Honor, if I do have contact with him, I'll welcome him to the courtroom.
Yeah.
Thank you, Your Honor. Have a good day, everyone.
You too, take care. All right, here on our 11th, Mr. Owens.
Yeah, he's coming in
Yeah,
now.
it's a whole. You get it.
Yeah, we got like, 9 witnesses for your 15 case.
What?
9 witnesses for what? For the 15 case.
The last one, the 2 defendants.
You're right, what's your name? Yeah, right.
Can we do that one?
Yeah.
Who did that?
No, that was the one we,
Oh,
that's the one you told me to come in with.
That's that prosecutor told me.
That was the part.
right, there was an issue, they had to,
Have permission.
Going on property, yeah.
Yeah, have permission. I don't know why I need that one. People.
No, it's not gonna take 9 more people. We'll do one witness that's gonna tell you that, I'm gonna dismiss the case.
That's your.
That's not yours. We're talking about that. We're talking about Beasley and, Ross.
That's a kid.
He's like, what? You ready, Mr. Davis?
Yes.
Parties ready on Antonio Fisher Owens, calling case number 2356778, the people of the state of Michigan versus Antonio Fisher Owens. Defendant is charged with count 1, weapons carrying concealed, count 2, count 3, police officer assaulting, resisting, obstructing, count 4, count 5, weapons felony firearm. This matter is scheduled for examination.
Good morning, Your Honor. Ed Booklet appearing on behalf of the people, P 86266.
Good morning, Your Honor. Restatement is P76203, agreeing with Antonio Fisher, who's present, and speaking to my right. What's your name, right?
Antonio Fisher Owens.
Morning, Mr. Fisher Owens. Looking very nice today, sir. Ready?
Yes, sir. The people would ask for a mutual order of sequestration of all witnesses, Your Honor.
No objection.
Right, and you know, witnesses testifying today at trial or any time in the future must be the courtroom or be denied at future testimony.
Compliance sit here.
Yes.
The people would call their first witness, Your Honor, Officer Ross.
Delante, DELANTE, ROSS.
Oh, this way.
Right here.
Okay, so you're right. You swear or affirm that the whole truth and nothing but the truth, so help you God.
Yes.
All right, close the door for you. That microphone right next to you, put it down. Yes, sir. Thank you.
Thank you, Judge. Officer, could you please state your name for the record one more time?
Delante Ross,
Where are you currently employed, Mr. Ross?
Detroit Police Department, 7th Precinct,
How long have you been with DPD?
almost 6 years.
I want to take you back to May 5th of this year, 2023. Were you at the location of 2010 East Jefferson Avenue?
Yes,
Is that in the city of Detroit, County of Wayne?
yes.
And what is at that location?
It's a mobile gas station.
Were you there in a work capacity at that time?
Yes,
were you working alone or with a partner?
I'm off with my partner.
What's your partner's name?
Police officer Yvette Hudson.
Okay, can you move the mic just a little bit further? Away from it, yeah. Okay, thank you.
Did you say Yvette Hudson?
Yes.
Were you in uniform at the time?
Yes.
What kind of uniform were you wearing?
Class C's.
What does that mean, class C?
Like I have on now, black top, gray pants. It says police on our vest, front and back.
Were you in a squad car or were you on foot?
A squad car semi-marked. It's a black, scout car with black font on it that says Detroit Police on the side.
Forgive me if I asked this already. What is at that location of 2010 East Jefferson Avenue?
It's a gas station.
It's a gas station. So, what are you and your partner doing at the gas station on that day?
We're showing special attention. We're on a downtown detail in Jefferson. It's our area to patrol and enforce the law down here, partying, drinking, loud music.
I want to direct your attention to just before 11, just before 11 p.m. that day. Did you observe anything that might bring us into court here today?
Yes.
What did you observe?
I've observed a male concealing a firearm.
So let's break that down. Where are you on this gas station at the time?
I was right towards the entrance. So I was on the other side of the pump, other side of the door.
Are you in the driver's seat or the passenger seat of the car?
I'm the driver.
And where do you see this male standing?
I'm at the gas pump.
Is he near a car or is he just standing there like just?
He was pumping gas.
Okay. How far away from him were you when you saw what you believe to be a concealed firearm?
Okay, well, you
I
can say
didn't
that. Well,
I can ask it. I can ask
you
it.
can ask Jeffrey.
How far away from him were you when you observed him?
A few feet.
What do you mean by a few?
From probably like here to the.
To Madam Court?
Yes.
So like 5 to 10 feet, maybe? So 10:45 p.m., that's nighttime, correct? In May? How could you see anything at the time?
The gas station was lit up. It was lights everywhere.
So what do you observe when you see this male about 5 to 10 feet away? What do you observe?
I observed a handgun under his shirt.
So let me stop you right there. How do you know it was a handgun?
I seen the handle like sticking out of his shirt.
Okay.
And he had on like jogging pants, shorts.
Okay. So what do you do when you see that?
I asked him, I rolled down my window and asked him, was he a CPL holder?
So you're still in your car at this time?
Yes.
Okay, so you asked him if he's a CPL holder?
Mm-hmm.
What if anything does he, before you even answer that, my apologies. Do you see that person in the courtroom here today?
Yes.
Could you please point to him and identify him by an article for record? Okay, thank you. Your Honor, what is he wearing?
He's wearing I don't know if that's a black or blue suit.
Your Honor, may the record reflect that the witness identified the defendant, Mr. Fisher Owens. Thank you, Judge. So you asked him if he has a CPL. Does Mr. Fisher Owens say anything to you?
He doesn't say anything. He had his headphones in at that time. I don't think he knew we were right there.
Okay. So what do you observe him do next?
I asked him again. He looked at us and I asked him again. And he took off his headphones. Then I asked him again. And he said, he just took off his headphones and began to walk away.
When you say you asked him again, what are you asking him again?
I asked him, was he a CPL holder?
And after he had taken his headphones off, you asked him that?
Yes.
And what, if anything, did he do after that?
He began walking away.
And what did you do when he began walking away?
That's when I exited the vehicle and asked him again, was he a CPL holder? And he told me he had to make a phone call.
Okay.
And he was still walking towards his vehicle.
So what do you do as he's still walking towards his vehicle? What if anything?
He was walking towards his vehicle, and that's when I reached for a firearm, and that's when he began pushing us away.
So
pushing me away.
Let me stop right here. Why did you reach for the firearm?
Because he was concealing a firearm and he was walking away towards his vehicle, and I didn't know whether he was about to flee or grab another weapon or load it up. At that point I didn't know, so I was trying to retrieve the firearm for safety. And he was ignoring us, not speaking with us.
So you said you reached for the firearm and you said that's when he started to push away from you. Is that what you said?
Yeah, I reached for the firearm and he kind of pushed me away.
Let me stop right there. How did he push you away?
I really don't recall, probably like his forearm, just like pushing us back a little bit.
Okay, so what do you do when he pushes you away?
That's when I grabbed him up against another vehicle, and I told my partner to retrieve the firearm while I hold, so he wouldn't grab it.
Did you observe your partner do anything at this time?
Yes, so when I first attempted to grab the firearm, he didn't have a holster, and he had a basketball short, so he maneuvered behind inside his shorts, and I observed my partner, because she couldn't find it at first because it fell down. So she grabbed it from his, inside his waistband and like towards his back area.
So what, if anything, do you do next?
At that time, I tried to detain him, by placing him in handcuffs, and he still was resisting.
How was he resisting?
Like just pushing away, like pushing me towards the back. Like I had him towards the back side that time, he just was pushing away.
Is he just pushing you away at this point?
Yes, at that time, my partner, secured the firearm and placed it, in our vehicle for safety. No one could pick it up or he couldn't reach it.
So did you observe your partner do anything after she put the gun in the firearm in the vehicle? Did you observe her do anything else?
Yes, she came back and I put him on the ground to try to place him in handcuffs. That's what she assisted me. I tried to call for help over the air, but we was in different districts, so I had her go to the vehicle again to call the other units from the detail we were working on downtown.
So what, if anything, happens next?
So at that time, my partner came back, we were assisting him. He grabbed a hold of her duty belt and she kept stating like, let me go, let me go. And I seen him hold the duty belt. I wasn't sure if he had like her gun or just like the duty belt, but he had the magazine in it up and he was like taking the bullets out of the magazine. And that's when I began like striking his forearm to like the hand that he had to grab her to try to have him release her.
What, if anything, did
Okay,
you?
wait. I didn't get something.
Okay.
You said defendant grabbed your partner's duty belt.
Yes,
Then you said something about, I got that part. You said something about, some magazine.
Yeah, he had the magazine, that's what he was grabbing.
On her duty belt?
Yes, on her duty belt.
When you say magazine, I just want to be clear, what is a magazine?
A magazine is for ammunition, it holds ammunition for our firearms.
So what, if anything, happens after you're striking this form? What happens?
We tell him multiple times to put his hand behind his back. At that point, he's still not saying anything, he's just resisting. He still had my partner. That's when more units arrived and helped us more to detain him.
Was Mr. Fisher Owens eventually detained?
Yes, he was eventually placed in handcuffs.
Did Mr. Fisher Owens provide a concealed pistol license at any point?
He did not.
Did you ever observe the firearm that was recovered?
Yes.
What kind of firearm?
It was a black semi-automatic handgun. I'm not sure of the brand right now.
Thank you, Your Honor. I have no further questions.
Officer, it's your testimony that you observed Mr. Fisher Owens pumping gas outside the vehicle, is that correct?
Yes.
Okay. You made contact with Mr. Fisher Owens, is that correct?
Yes.
You asked him if he had a CPO, is that correct?
Yes, sir.
Okay, at some point you drafted a report after this incident, is it that fair to say?
Yes, sir.
You wrote it in your own words?
Yes, sir.
How long after the incident did you write the report?
I'm not sure of the timing.
Would it be days, weeks?
No, it would have been a few hours. We had to wait to impound his vehicle, get investigated for the use of force.
Okay, you drafted exactly what happened, what in your report, is that correct?
Yes.
Okay, and in your report, do you recall ever mentioning actually seeing a firearm prior to asking Mr. Fisher Owens if he had a CPO?
I described, how the firearm was concealed in his waistband.
And how did you describe it?
In my report, I don't recall, I didn't read my report before I came.
Okay, would it refresh your recollection if I provided you with a copy of your report?
Yes.
Mr. Approach.
Yes.
You had the opportunity to review your report?
Yeah, part of it, yeah.
Okay. In that report, did you ever mention actually seeing a firearm on Mr. Fisher Owens' waistband?
No.
In the report, you said that you saw an L-shaped bulge, isn't that correct?
Yes.
Okay, but yet you came in today and testified that you actually saw the firearm on Mr. Fisher Owens' waistband, isn't that correct?
I stated I saw the handle of the firearm.
You didn't mention actually seeing a handle of the firearm in the report, isn't that correct?
It's the L-shaped bulge. The L is the top L is the handle and the bottom is.
So the report is accurate, correct?
The report is accurate.
Okay, you saw the L-shaped bulge of a firearm, is that correct?
I seen an L-shaped bulge consistent to a firearm.
That's what you observed on the day?
Yes.
Okay. All right, and then you noticed that L-shaped bulge, correct?
Yes.
Asked Mr. Fisher Owens if he had a CPO, is that correct?
Yes.
And you didn't get a response, right?
I did, he had his headphones in.
Yeah, he said, well, so you're not sure if he heard you, right?
Right.
So then you walked up to Mr. Fisher Owens and grabbed him, is that correct?
Negative.
Okay.
I asked him again. He made eye contact and took his headphones off. And that's when I asked him again.
If he had a CPO?
Yes.
And he didn't respond in the affirmative or negative, correct?
Correct. He began walking away.
He walked away. Okay, and then at some point you grabbed him, is that correct?
Not at that point. I exited the vehicle and asked him again, was he CPO order? That's when he still was walking his vehicle.
Okay, and then you grabbed him, right?
I grabbed the firearm.
Okay, you reached on this person and grabbed something on his waist.
Yes.
Okay. And at the time that you grabbed the firearm that was on his waist, he hadn't committed, to your knowledge, he had not committed a crime, is that fair to say?
He was being investigated for carrying a concealed weapon.
But you didn't know whether or not he actually had a CPO, isn't that correct?
He didn't give it to us upon request.
My question is, did you know at the time that you grabbed the firearm off of Mr. Fisher Owens' waist whether or not he had a CPO?
At that time, no.
Good. Then a couple seconds later, another officer pulled up, isn't that correct?
It wasn't safe. It was more minutes when a rival came with assistance.
Okay, someone else pulled up and they were able to secure the firearm and place it somewhere else, isn't that correct?
No. My partner was already with me.
So your partner was with you,
Mhm.
your partner came and she secured the firearm, right?
Yes.
Okay, within a few seconds after you initially made physical contact with Mr. Fisher Owens, correct?
Yes.
Would you say less than 10 seconds or so?
I'm not sure.
If you had to estimate, less than 30 seconds?
Less than 30, yes.
And the firearm was secured and when it was taken to the vehicle, is that correct?
Yes.
Locked inside the vehicle, right?
Yes.
And then she assisted you with the arrest of Mr. Fisher Owens, is that correct?
She assisted me, yes.
Okay. And the entire time while you were arresting Mr. Fisher Owens, he no longer had the firearm, is that fair to say?
He no longer had the firearm, yes.
Okay.
No reason, Your Honor. All right, thank you.
Just goes there. People have no further witnesses and will rest.
Okay.
No witnesses.
Yeah, of course, Judge. The people have moved for a bind over on all counts here, Your Honor. As we heard from Officer Ross, he noticed what he believed was consistent with an L-shaped bulge. He asked Mr. Fisher Owens several times whether he had a CPL, asking multiple times even after Mr. Fisher Owens took his headphones off to make sure that he could understand him. Officer Ross did repeat it again. At that point, Mr. Fisher Owens started to walk away, and he never gave any answer into the affirmative or the negative of whether or not he had a CPL or not. If Mr. Fisher Owens did have a CPL at that time, he would have failed the mandatory disclosure under MCL 28.425C, where CPL carriers do have to announce to law enforcement officers or peace officers that they have a CPL and whether or not they are carrying a firearm. Mr. Fisher Owens never provided a CPL to Officer Ross or his partner. In fact, when they continued their investigation, Mr. Fisher Owens started to assault them by pushing Officer Ross and grabbing Officer Yvette Hudson's duty belt, and even according to Officer Ross, flicking the ammunition out of her magazine. Your Honor, I believe the people have met their burden here and would again ask for a finding. Thank you.
How are you connected to a felony firearm?
Well, when he originally starts the resisting, Your Honor, he has the firearm on him. And it wasn't until Officer Yvette Hudson took the firearm from him.
Which happened almost immediately. He went to grab for it. And then Officer Hudson then grabbed and took the firearm.
Yes, Your Honor, but it was after Officer Ross had already been pushed once. I understand Your Honor's argument for the felony firearm connected to the RNO on Officer Yvette Hudson.
There is no RNO on Officer Yvette Hudson. I mean, there is no felony firearm on that. I mean, you don't have anything on that.
Right, I understand.
You know, what you have on the other officers.
Question of fact.
Put it that way.
I understand, Your Honor. I understand.
All right, well, I understand your argument.
Thank you, I appreciate that. I just want to make sure for the record that it's clear that Your Honor is saying that there's no felony firearm on the RNO against Officer Hudson, not that there's no RNO on Officer Hudson at all. I just want to make sure.
Right, that's a felony firearm.
Understood. Thank you.
Yeah, Judge, that's my exact argument. But in addition to what the court is saying, there's no blanket law that says anytime an officer is walking down the street, they can just approach a person and say, you have CPL, that person has to respond to it. My client's standing at a gas station, pumping gas, the officer says, notice that L-shaped bulge, begins to question my client doesn't have to respond to that officer. And then the officer proceeds to search my client, not knowing whether or not he's actually committed a crime. You know, I don't believe we can subject every person in the city of Detroit to this type of unreasonable search and seizure. The client had not committed a crime. He was approached by the officer and had something that he was carrying removed from his waistband. Grabbed my client's waistband, retrieved something from his waistband, and at that point, I believe that the search was unlawful. It violated my client's Fourth Amendment rights. Then, in addition to the violation of my client's Fourth Amendment rights, there's no connection to the felony firearm. Any resistance that occurred after the firearm was secured inside of the vehicle. So I just asked the court to dismiss the charges.
As it pertains to the search and seizure, Your Honor, I would again point the court in the direction of MCL 28.425C, the mandatory disclosure. And Officer Ross, when he did inquire about the CPL, it's not that he got an answer one way or another, but Officer Ross also did say on the stand that he saw the handle of the firearm. So at that point, and with the he said basketball shorts that he was wearing, Your Honor, I believe that the people in that room again.
With respect to
no further argument. Thank you. Court having heard the argument, testimony finds as follows. Officer Ross, Detroit Police Officer at 5527, sometime a little bit before 11 o'clock p.m. in the area of 2010 East Jefferson, the old gas station. He was on duty in uniform in a semi-marked vehicle, paying special attention to the area. He observed the males at the gas pump approximately 5 to 10 feet away. he observed. Initially, his testimony was a handle of a gun sticking out of from his shorts. He also testified that in his report that he saw an L-shaped object. He rolled down his window to speak to the defendant, asked him if he had a CPL. He said the defendant had his headphones on and he didn't think he could hear him. So he got out of the vehicle, began to approach him. Then he got the defendant's attention, asked him again if he had a CPL. After he had removed the headphones, the defendant did not respond. They said something about had to make a phone call or walking towards his vehicle. That's when the officer physically began to reach for what he thought was a weapon, grabbing the defendant. Now, the issue that's kind of unclear for me was whether or not the push in regards to the officer occurred prior to the other officer retrieving the weapon, same time the other officer retrieved the weapon, or before the other officer retrieved the weapon. You know, I'm not quite sure in terms of the testimony that was given, but then that just makes it a question of fact. So the officer had when he saw what he thought was a L-shaped bulge, or he saw the butt, or he said the handle of what he thought was a handgun, and he approached the defendant. It is law that the defendant is required at that point to say, tell the officer. But anytime you come in contact with the officer and you have a weapon, you're required by law to tell them, I have a weapon, I have a CPL. And then that's, at that point, it should be the end of it. May ask for either CPL, which you can show it if you had one. So at this point, so the court is basically all a question of fact. Court finds that the felonies enumerated complaint warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant to be bound over to Wayne County Circuit Court's criminal division for arraignment on the information, which will be June 5th at 9 o'clock.
Thank you, Judge.
Good.
Thank you.
You ready?
Yes, ma'am.
Yes.
Kim, you ready?
Yes.
Calling case number 2356668, the people of the state of Michigan versus Anthony Ruff. Defendant number 1 is charged with count 1, motor vehicles operating a chop shop. Count 2, breaking and entering a building with intent. The people of the state of Michigan versus Timothy Beasley Jr. Defendant number 2, charged with count 1, motor vehicles operating a chop shop. Count 2, breaking and entering a building with intent. Count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Matter scheduled for examination.
Ryan Lukowski for the people, P73132.
And good afternoon, Mayor David Cripps, P34972, appearing on behalf of Timothy William Beasley Jr., who joined us in court. Tell the judge your name.
Defendant Timothy Beasley. Good afternoon, Your Honor. May it please the court. My name is Mark Brown. IP number is 39562. I'm here on behalf of Mr. Anthony Ruff. President of the court, Mr. Ruff, state your name. Anthony Ruff. And Judge, for the record, Mr. Ruff was not present during the initial date of this exam. We have no objection to continuing with the exam now. I've explained to him what the nature of the testimony was given during, there's one witness, one police officer explained to him, and we're prepared to proceed.
Okay. All right, give me 1 minute. I have a motion here before I go. All right, since we see this motion already.
Your Honor, I gave a copy to Mr. Cripps this morning. I also filed it early this morning. I worked on it briefly over the weekend, and that's why I filed it, because I did not foresee that issue coming up, but I wanted to address it based on the comments of defense counsel and both the court, the last hearing. And I just wanted to say, as a procedural matter, I'm trying to comply with the court's, I guess, directives to get those witnesses that the court wanted to hear here. I just have a different position as to what would the result be if I did not get them here. And I felt I needed to file that just to put that position on the record in writing. Thank you.
Any comment?
I'm willing to proceed here with the proofs that you directed him to provide to the court.
Based on this motion, obviously, you can't provide it. Is that correct?
Your Honor, again, I want to be.
I'm not addressing the issue of what you put in here. I'm addressing the issue that I presented last time we were here. You cannot show that, correct?
I have Mr. Elliott Say here. He is the property owner. It's my understanding he will testify to phone conversation with Marcus Smith.
Who's Marcus Smith?
The property manager. He indicated no one but Marcus Smith had authority.
Okay, that's not the issue I'm talking about.
Okay. Marcus Smith subpoenaed, and I was just told by the OIC was going into oral surgery at 12:15. I can get him here another day. I can't control his oral surgery. My subpoena did say Marcus Smith or other property representative. I can put the owner on as to no permission, which I believe gives a piece.
Well, putting the owner on is that deals with your motion as you provided it today, the motion to limit. That doesn't deal with the other issue at all.
Being the timing of the call, Your Honor?
I don't care about what difference does the timing to call me? You have to show. Okay. All right, let's see, put on your witnesses, I'm gonna make a rule. Whatever you got on,
Okay,
I'll make a rule.
okay. Your Honor, I have other civilians here that I'd like to call first.
And give me an offer of proof, what do you mean other civilians, how many are we talking about?
To Your Honor.
For what?
The
What are they
owner-
gonna say?
The owner of the vehicle. They'll say no permission for anyone to take that vehicle, and they will also testify to key fobs.
What do I care?
Your Honor.
What difference, I already got the officer saying that there was a vehicle, one vehicle in this garage and that vehicle came back stolen, so I got that. So why do I need the owners of the vehicle? What are they gonna say that I haven't heard?
That they were when they purchased the vehicle, they were given 2 key fobs, they both said Jeep on them.
What do I care?
It goes to prove that it's a stolen vehicle, and that.
You already got that from the officer, what do I care about the key fob?
The fob that was recovered was reprogrammed for that vehicle.
And they're gonna testify to that?
No.
Okay, then I don't need them. Who else
Officer
you
Brooks
got?
testified he recovered a key fob that worked to the car.
No, he said he recovered a key fob and had no make or model on it. That's what he said. He didn't say it worked for anything. He said he had recovered a key fob that had no make or model on it. That's what he said.
And I apologize.
That's what I wrote down.
Okay.
Now, I don't need these other folks to say that he got a key fob when they got the car. I don't care, so what? The point is, I got a car already. I already got evidence on his record that this car was stolen. So why do I need them? This is not trial.
I thought you were against hearsay, Your Honor. So I'll release those witnesses if the court's satisfied.
That the car in this garage was stolen.
Yeah.
Yeah, I'm satisfied with that. He checked it on me.
And you don't think it has, I'm just checking with the court before I release my witnesses, that the fobs that they were, 2 fobs that they were given, they retained, and they both said Jeep on them, so it's not this fob that was recovered at this.
All I have as related to this fob that was covered on the scene is that it was, key fob had no make or model on it. That's what I got. That's all I got. Those witnesses can't testify to anything about a fob recovered on the scene.
Oh, I know, Your Honor.
Okay, so what else would I need? As to them, I don't need to hear them then.
Okay, Your Honor, I'll release them.
Okay, so what else do you have?
Mr. Say, the property owner, he can testify that, on the date in question, no one other than Marcus Smith had permission to be, on the premises or in the garage, and that he, had, the general, not exact, the general timing of the conversation, and that, what he directed Marcus Smith to do as his property manager, he being the property owner.
Okay. What element does that go to?
He told him to call the police, Your Honor.
You told him, okay, so what?
So, Mr. Beasley and Mr. Ruff had, they didn't own that property, they didn't have any possessory interest in the property, they were not even there legally. That's where it goes.
Okay, so they were trespassers just like the police were.
And Your Honor, that's my, if the property owner tells the property manager, I want the police to respond, I would argue that that's permission.
No, it's not. Plus, it has to be the people that respond. I don't know who he called. He could have called, like I said, Lieutenant Joe Blow, who's on vacation in Florida, because that's a person he knew. Now, the police know. Well, what you're saying, the police know, because he called Lieutenant Joe Blow, who's on vacation in Florida, before this happened. No, let me finish. The police that were there had to have permission or warrant. That's the way it works. Not somebody who is in administration or wherever, or a dispatcher answering a phone. You know, that knowledge is not transferred unless it is transferred. And we already know it wasn't transferred from this officer that testified. So you want to put what other witness you got?
Oh, I have all the officers.
They gonna say anything different than what this officer said?
I think, I would probably call Officer Edwards for having he actually dealt with Mr. Beasley.
What does that mean?
Oh, there was questions about, where they were in the garage and what they heard and that stuff, that sort of thing. And my recollection of the testimony is Officer Brooks did not deal directly with Mr. Beasley, that was Officer Edwards. And I might recall Officer Brooks, if the court would allow to talk to Mr. Ruff. We didn't do that before we got into the, I guess what I would say, a constitutional issue of search and seizure, that I wrote the motion.
Okay, so what's the officer talking to Mr. Rupp? What do I care where they were in the garage? They were in the garage, I got that. I mean, what do I care?
It goes to their relative position, to consciousness of guilt.
No, it's not trial, no. This is how you get, okay, let me put it this way, how you get past mere presence in this case? Because you ain't got nobody, you haven't had anybody, to say that they did anything to any part of that car.
The window was broken.
So?
There's a reprogrammed.
No, I don't know, no, I don't have that on the record.
There's a key without any markings, which is not the same as a manufacturer's key.
So?
They're crouching behind the vehicle. They're not responding to calls of, hey, anybody in there?
It's dark in there, there's no lights, okay? Again, you have mere presence, so how you get consciousness of guilt? How do you get that they did anything? Maybe they were gonna do something, maybe they decided they were gonna go over there and take whatever they thought they could take. But you still can't connect them to that car, you haven't.
And Your Honor, I apologize, I didn't expect to give, I also had notes indicating that the car was in intact, perfect working order before it was stolen, so there's no reason to take off the fenders of the grill. It goes to count.
Who took off the fenders in the grill?
Count one, the chop.
Who took off the fenders in the grill?
I would argue that that presence in the garage with the other officer's testimony will make that a question of fact, whether Mr. Ruff and Mr. Beasley were doing it.
Bring another officer. Go, because right now we're just wasting time.
Okay.
What's the officer's name? What's the officer's name?
Oh, excuse me, Your Honor, I didn't hear that. Brian Edwards, Brian Edwards, standard.
R-I-A-N Edwards, A-W-L. Need to go your ear, yes.
Raise your right hand. You swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God. I do. You have a seat.
I'm good. Oh, sorry. Thank you, Your Honor. Sir, can you please state your name for the record?
Brian Edwards.
And on April 28th, 2023, what were you doing for a living?
Police officer in the city of Detroit.
And are you still so employed?
Yes.
And on that date, April 28th, 2023, in the early morning hours, did you go to the address 17801 McDougal Street in the city of Detroit, county of Wayne, state of Michigan?
Yes.
Okay. Why did you go
911 call for a person with a weapon.
Okay. And did it call out that address?
Yes, sir.
Okay. And if you recall, were you specifically looking for?
It's not lead.
I'm sorry?
About the lead. You say, are you specifically looking for, you need to rephrase the question, please.
Based on conversations you had with dispatch, were you looking in any specific area on the premises of 17801 McDougal?
Yes, the garage.
And can you describe, let me back up. How did you get there?
In my patrol vehicle.
And were you alone or with any other Detroit police officers when you arrived?
I was with two other Detroit police officers.
Do you recall their names?
Yes, Officer Xavier Brooks and Officer Colin Swart.
Okay. And can you describe what happened when you arrived on the scene?
We arrived on the scene, had an assistant unit, it's about 11-2. Which contained officers, Cowan and Officer Curry. Officers went to the garage. Officers shortly after made entry. I observed Timothy Beasley. I detained that male. I observed him stripping the car prior to the detainment of him. After I detained him, I walked him back to the front of my stock car.
I see. You referred to someone as Timothy Beasley. That person, do you see that person in court today?
Yes, sir.
Can you point him or her out and describe what he or she is wearing?
Timothy Beasley right there. He has braids and black collar shirt.
Yeah. I'm sorry, I can't hear very well. Could you say that?
Timothy Beasley is right there. He has braids and a black collar shirt.
Your Honor, I'd like the record to reflect that the witness identified defendants, now two in this matter, Mr. Timothy Beasley Jr.
Correct, so reflect.
You mentioned you observed Mr. Beasley taking action. Can you describe what that action was?
Yes, sir. When I made entry into the garage, I observed him crouch down in front of the vehicle on the driver's side, as if he was removing the front bumper from the vehicle.
Objection. Strike that part, and just, you let us specify what you saw, not what you think you saw.
You saw Mr. Beasley in a crouch position?
Yes, sir.
Okay. You mentioned there was a fender nearby. How close was Mr. Beasley to the fender, or was he actually touching?
And now you leave.
Close to the.
Hold on. Rephrase.
Can you describe? I apologize, Your Honor, I'm stepping all over you, I'm sorry.
Go ahead.
How close was Mr. Beasley to that?
Wait. What are you doing? You have pictures in your lap. Are you reviewing something?
No, I was grabbing them, they were falling here.
Oh, okay. Just checking. Wasn't sure.
It was about, don't recall, maybe, I don't know.
Okay. Was he closer or further than I am to this plexiglass?
But he just said he doesn't recall. Now this is leading.
It's leading.
With someone who doesn't recall something.
And Your Honor, the very question before that is, he said Mr. Beasley was near a fence. I think it's permissible follow-up.
And just, it's not my crime, but he said. He said he
Mom,
was crouching down in front of the vehicle. I got it. And when you asked the question about Fender, I told you you were leaving. So I wouldn't have taken his answer regardless. Okay, so now, then he asked how far, and he says, I don't know. I mean, I can use my common sense, he's inside a garage. There's a car inside the garage. I'm sure there's not a whole lot of room to maneuver. I don't know if this is a 1-car garage, a 3-car garage, a 10-car garage. I don't know. We ain't got that far yet.
Can you describe the garage, Officer Edwards?
Yes, sir. Garage had a door on the left side of the garage. That's where we made entry into. And it appeared to be a 1-car garage.
You said Mr. Beasley was at or around the driver's side, if I remember you correctly?
But you said in front of the car.
Said in front of the vehicle, so his testimony.
Was, if you could tell, was Mr. Beasley more closer to the driver's side or the passenger side of the vehicle?
We're closer to the driver's side of the vehicle.
Now, the front fender, or sometimes it's referred to as a quarter panel, on the vehicle, at the time when you first observed the vehicle, was that fender off or on?
It was off.
You mentioned Mr. Beasley was in a crouch. Did he appear to have anything in his hands or?
Now you're suggesting facts that are not in evidence.
Describe what happened when you entered the garage and your attention was first drawn to Mr. Beasley.
I took the garage, I observed him in a crouch position. Then stood up, I ordered him to turn around and face the wall. I placed handcuffs on him. After, I walked him out of the garage and to the front of himself.
Did you see, other than other police officers, did you see anyone else in that garage?
Yes.
Do you see that person or persons in court today, the other person that you saw?
Yes.
Okay. Can you point to that person or persons and describe what he, she, or they are wearing today?
He is right there. He has braids with a gray collar shirt on.
Your Honor, I'd like the record to reflect the witness identified defendant one in this matter, Mr. Anthony Ruff. What was Mr. Ruff doing when you entered the garage?
Mr. Ruff was also in a crouch position next to Mr. Beasley.
How close was Mr. Beasley to Mr. Ruff?
Can't give it the exact number, but they're pretty close, not that far apart.
Did you specifically take any actions towards Mr. Ruff?
No.
Did you observe other officers take actions with regard to Mr. Ruff?
No.
If you recall, we keep mentioning, or I keep questioning this vehicle. What do you recall? What sort of vehicle that was? Make, model, color?
Red Jeep Grand Cherokee.
Did you observe any items in the garage?
No.
Did you make any recoveries?
Yes.
Can you describe what you recovered and how that came about?
Yes, once the vehicle was confirmed stolen, and I began to place Mr. Beasley under arrest. I did a search of his person in front of my scout car, where I located multiple narcotics in his waistband.
Objection to speculation.
Objection sustained. Suspected narcotic.
Suspected narcotic.
Item you referred to as suspected narcotics, was there any sort of packaging, or was it just the substance itself? Or?
The suspected narcotics were in clear knotted baggies.
And inside that clear knotted baggie, can you describe the substance with liquid, solid, powder, color?
Multicolored pills. He also had suspected powder substance in a small knotted bag as well. Along with some white pills in a small knotted bag, and crystal-like substance, a hard crystal-like substance in a knotted bag as well.
Without telling me any content of the conversation, were you aware of anyone on the premises who said they represented the owner of the premises? Without the
Objection is hearsay.
No, but no, you can answer the question, strike the answer. It's hearsay because you're suggesting an answer. You're suggesting facts.
I'll move on, Your Honor.
Not in evidence. So please, if there's an objection made, just stop talking. Okay, my apologies. No problem. Thank you.
I specifically asked you about the right fender or right quarter panel. Can you describe just generally the condition that you recall that the vehicle was in, whether there were other parts that appeared to be off or missing, or what you observed?
Isn't this a cumulative testimony? Why are we going back to this? I already got that. And that was my whole point of asking you for offer of proof initially as to what he's going to tell. I don't need him to testify the same thing the other officer testified to. I got the condition of the vehicle.
Okay.
I got that.
As far as, other than what you saw, can you describe what you heard as you were approaching the garage?
I didn't hear anything approaching the garage.
The relative position of the door of the vehicle and where you saw the each Mr. Beasley and Mr. Ruff, was the vehicle in between? So when they were crouching down, they were obscured, or were they nearer to you on? Can you describe their relative positions when you notice this crouching?
Just asked and answered and leading. Josh.
I don't.
Yeah, how is it relevant? I mean, I got, he testified, he saw both of them in there. He testified where they were, and then they were crouching down. How is that question, or this line of questioning, in any way relevant to elements of this offense, any of these offenses?
Your Honor, it goes to knowledge that the vehicle was stolen for.
No, it doesn't. That does, because they're crossing down? Come on.
Yeah, because if they're crouching down
Well,
on the
let
opposite side of the
me
vehicle,
make
they're
it clear.
hiding.
I'm making a rule it doesn't, so let's go on to something else. Go on to something else.
I have no further questions, Your Honor.
No questions.
I have no questions, sir. Thank you. You can step down.
The people call Elliot Sayer.
Just manager or whatever, property manager.
The owner.
Owner, all right.
Elliot Sayer, I think you might be in the side room.
So realistic.
No, I'm not, I don't seem to be making too much headway, so I'm just gonna keep. I just feel like I gotta make a record.
Well, I know you gotta make a pretty good record. See this,
Great, great.
Your first name, please?
Yeah.
Elliot, Elliott.
One, two,
Your last name?
three,
C.
S-E-A-Y.
A. Sorry. Spell it again, please.
S-E-A-Y.
S-E-A-Y. Perfect. Have a seat in the witness box. Please keep your, this way, sir.
Over here.
Keep your voice up nice and loud, okay?
This way, sir. Right there. Stop, 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 stop. Look at me. Raise your hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, pull the door towards you. Right there, sir. Mr. Is it say or say?
C.
Huh?
C.
C, Mr. C?
Yes, sir.
All right, Mr. C, you're gonna be asked a series of questions. First, the prosecutor will ask you some questions. Defense may ask you questions, and I may ask you questions. All right?
Yes, sir.
You have to answer all your questions out loud verbally using words. Just think, shake your head and say, You have to say yes, no, whatever the answer is, okay?
Yes, sir.
Also, when you ask the question, I need you to listen to the question and just answer that question and stop. If it's a yes or no type question, just say yes or no and stop. All right?
Yes, sir.
You know, sometimes I have a tendency, we want to expand because we want to get all everything we want to say out. So we'll say this happened and this happened and this happened. If you do that, it's a strong likelihood I'm going to miss something. If I miss something, I might not make the right decision. Okay?
Yes, sir.
And also, if you hear one of the attorneys, or if I start to talk during your testimony, just stop. If you hear someone say objection, or if I start to talk, then just stop talking. Okay?
Yes, sir.
All right, thank you, sir. All right, may proceed.
Okay. Mr. Say, are you familiar with the address 17801 McDougal Street in the city of Detroit, County of Wayne, state of Michigan?
Yes, sir.
And what is that premises? And what I mean by that, is it a apartment building? Is it a single family home? Well, what's on that premise?
It's a single family home.
What's your relationship to that premise?
I'm the owner.
Does that premises have a garage?
Yes, sir.
Is that garage attached or detached?
Detached.
In April of 2023, were you the owner of 17801 McDougal, City of Detroit, County of Wayne, State of Michigan?
Yes, sir.
During that time, the whole April, who had permission to be on the premises?
No one.
Did you have someone who helps you out on the premises?
Yes, sir.
Do they have permission to be on the premises?
Yes, they have permission.
Who's that person?
Marcus Smith.
And does he have some sort of title? Or is he just backed up?
He's my property manager.
Do you recall having a phone conversation with Marcus Smith in the early morning hours, April 28, 2023?
Yes, sir.
Without did you direct Mr. Smith to contact the police?
Yes, sir.
Can we get through this without leading?
In the most
You offered it, the question you put forth had evidence, facts that are not in evidence. It's a leading question. If it's procured against the rules of evidence, I can't take it.
Your Honor, I think the leading question suggests an answer. I don't suggest yes or no. The answer could have very well been
A
no.
leading question can also be when you put facts that are not in evidence into the question. Then it becomes leading, because now you're suggesting an answer.
Describe the conversation you had with Marcus Smith on April 28th, 2023.
Okay, now you're asking a civilian for hearsay testimony.
Well,
Because he's
either-
not gonna, let me finish, counsel. He can say what he said. He can't say what Mr. Smith said, because that's hearsay. And when you say describe the conversation, you're asking him for the whole thing, which means you're asking him for hearsay.
Your Honor, I'm trying to get to the point without eliciting hearsay, so that's why I asked.
I understand, but I have to follow the rules of evidence.
As best you can recall, Mr. C, excuse me, I keep mispronouncing it. Just give me your side, what you told Mr. Smith, without any context, without saying what he said. Can you tell me what you told Mr. Smith?
Well, someone had hit, someone called him.
Well, objection.
No, what you told him.
Objection.
What I told him.
Okay, stop. Oh, go ahead. Go ahead. What he told Mr. Smith. That's all. What you
Just
told him.
just your side of the
I
conversation.
told him to call the police.
By doing that, was it your intention, or was it your meaning that police had permission to enter the premises?
Again, it's hearsay, you're suggesting.
I'm asking about his intention.
And you're suggesting it in the question. That's what makes it improper. You can't put it in the question. You can't suggest the answer in the question.
What was your intention when you told Mr. Smith to call the police?
Whoever was inside the property. My knowing about the police, when you call them, they're supposed to come to see what's there. If they're at the entrance, it's fine with me because they the law. Not like I have to meet them here. I'm calling the police for help. Someone broke into my property.
Objection, Your Honor. There's no foundation.
And Your Honor, it's his state of mind, it's what his intention was when he's speaking to Mr. Smith. I think it's proper testimony.
That someone broke into his property?
And he's calling the police for help.
He's calling the police to go check something out. That's what I got. Well, he didn't call the police. He's telling Mr. Smith to call the police. That's what I got.
Who's his agent as he's employed.
I understand that. I got that. I got that part. I got it. Trust me.
Do you own a red Jeep Grand Cherokee? Did you give anyone permission to put a Jeep Grand Cherokee in the garage at 17801 McDougal?
No.
Did you give permission for anyone to put fenders and a grill of a red Jeep Grand Cherokee in your garage at 17801 McDougal?
No.
I have no further questions.
No.
I have no questions.
No questions either.
Thank you, sir. Let's go down. Anything further?
Yes, Your Honor, the people call Sergeant Spencer.
We offer proof, what is he gonna say?
Oh, I believe he's gonna say he properly performed a drug analysis.
Oh. Right. And that's
Sergeant Spencer.
Marcus Smith. That's Marcus Smith?
No, his last name's Spencer.
Oh, Spencer.
Sorry, I'll speak up now. Spencer.
What's his first name?
It just says T, I'm sorry, Your Honor, I don't know.
Okay.
Spencer?
Yes.
Have your first name?
Tyrone, T-Y-R-O-N.
Spencer, S-P-E-N-C-E-R.
C-E-R,
You swear or affirm the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
Hold the door towards you, have a seat, please.
Please state your name for the record.
Tyrone Spencer, Sergeant with the Detroit Police Department.
And, do you perform preliminary analysis for the Detroit Police Department?
Yes,
And, on April 28th, 2023, did you perform any tests?
I did.
And, Your Honor, may I approach with what's, I'd like marked, people propose exhibit number 1?
Have you shown it to council?
Yes.
Yes.
Or I showed it to him last hearing, Your Honor. Rejected. Yes. I need that. Thank you. Your Honor, may I approach the witness with what's been marked, people propose exhibit number 1?
Yes. Any objection?
No, no objection.
Oh, Your Honor. I've handed you a 3-page document. Do you recognize that document?
Yes.
Okay. What is it in regards to?
One of them is the preliminary lab sheet for narcotics that were submitted to be tested. And the other two are TrueNarc scan reports from narcotics that were tested also.
Okay. As relates to, well, first of all,
I think the phrase should be alleged narcotics, right?
are you the author of this sheet or report?
No. My name is, I'm sorry.
Just wait for the question.
Oh, please describe,
The arresting.
No, wait, what's the question?
Your name appears about 3/4 of the way down on this form, is that correct?
At the top where it says requested by, and also at the bottom.
Are you the specific officer who performed any of these tests?
Yes,
Did you do the test specifically where it's marked fentanyl?
yes,
Did you properly perform the test on those pills?
Your Honor, this, I object to the form of that question. It's up to the court to make that decision.
It's the court's determination.
Okay. How do you test those pills to determine that they were fentanyl?
the fentanyl pills were tested with chemicals. There is a small pack that we use, a chemical pack from NIC Corporation, NIK, and I take a portion of the pill, put it in the pouch, and then you crush the tubes that are within the pouch for a specific color.
And were you trained in them?
Yes.
Okay. What sort of training did you have?
Training through the Detroit Police Department. At the time, the crime lab was open.
And did you follow, did you test these pills on, with regard to this fentanyl, in accordance with those, that direction?
Yes.
On the top of that report, top right, what's the incident number of that report?
230-428-0026.
And did you fill out any other parts of this form, or no, you said you weren't the author of this form?
That's what he testified to, Your Honor. It wasn't the author of the form.
Right.
Did you fill out this form?
I filled out where my name goes. The arresting officer fills out the form.
Okay. Okay. So, do you get the form with the substance, whatever it is, pills, baggies?
I don't understand your question.
Does the officer hand you the form already filled out?
Once he completes it, then I conduct my test.
Okay. He doesn't, specifically what part does he fill in?
Judge, he's not the author of the form.
What are we doing here? You want him to ask, that's not his form. He gets the form, he signs it, he does his test. I got that. Well, I do the test. I got that.
Okay.
I guess I'm not understanding. Let's go to something that's relevant. Please.
Who was the officer who gave you this form?
He never testified they received it from an officer, Your Honor.
We testify the officer fills it out.
Right.
Can you rephrase the question, please?
Who was the officer who participated in filling out this form?
Judge, I don't know how you would know that unless he was present. No foundation.
All right.
Who's the officer who gave you the form?
There's no.
There's nothing on the record that the officer gave him the form.
Okay. Describe how you first saw this form.
It was given to me by P.O. Edwards, Detroit Police Department. He was a confiscating officer.
And did he give you, the items that you tested as well?
Yes.
And where there's a check mark next to fentanyl, did you mark that?
Yes.
And that's because you performed the test for fentanyl?
Yes.
And you performed this test on April 28th, 2023?
Yes.
No further questions, Ron.
All right, I have no questions.
Also.
And, Your Honor, I apologize. I'd like to recall Officer Edwards.
I object to it, Your Honor.
So he can testify to that he put the incident number on the form. For the items. That's my fault. I apologize, Your Honor. He's here. He's ready to go.
Right. Brian?
Yes.
That's right.
Upstairs is still on gold. Thank you. Thank you.
No problem. Your Honor, may I approach the witness with what's been marked People's Proposed Exhibit number 1?
Yeah.
For the record, I'm handing the witness what's been marked People's Proposed Exhibit number 1. Do you recognize that document, Officer Edwards?
Yes.
You spoke about recovering items with regard to Mr. Beasley. Did you fill out the top of this one?
Yes.
The items described on this form, are they the items you recovered from Mr. Beasley?
Yes.
Did you write the incident number on the form?
Yes.
What is the incident?
It's gonna be 2304280026.
And did you hand the items you recovered to Mr. Beasley to Sergeant Spencer?
Yes, sir.
Did you hand him the form that you filled out the top of?
Yes, sir.
Is that form appear to be the form that you're holding People's Proposed Exhibit 1 or an exact photocopy thereof?
Yes.
Your Honor, the people would move for the admission of People's Proposed Exhibit
Number what?
No,
2?
yeah.
1.
And that has no relevance to my client.
Right. Admit it.
No further questions for this witness, Your Honor.
Any cross?
No questions.
Okay, thank you.
Your Honor, I am scheduled for a preliminary examination at 1:30 in Clinton Township. This matter was scheduled for 11:30 this morning. My client was here, Mr. Cripps' client was here. And I'm only saying this because I don't know
I'm
what we're
assuming
doing.
you don't have any more witnesses, correct?
Your Honor, I could,
I'm not asking what you could, I'm asking, do you have any more witnesses?
based on what Your Honor's directed me, no, Your Honor, I take after the rest of them.
So you rest.
Yes, Your Honor.
Does have any witnesses?
No, Your Honor.
On behalf of Mr. Beasley, no witness.
And likewise, no witness.
Make your argument.
Your Honor, Mr. Beasley nor Mr. Ruff were in a garage. They weren't responding. It was dark in the garage. They were seen crouching in a small garage. When police came upon them, the police were called there. One officer testified it was stripping of a vehicle. The other officer testified it was a person with a weapon, which, Your Honor, that officer, Officer Edwards, would qualify as that's an exigent circumstance to clear the area. You heard from the property owner who testified that no one else had permission other than his property manager to be on the property. Mr. Beasley and Mr. Ruffin were trespassers. There was a car that was, this is my term, partially disassembled in that the grill and the fenders were removed. The grill and the fenders being removed were the same color as the body color. They matched, which would be at least some indication that they belong together. Your Honor, there was a testimony of Mr. Brooks that there was a metallic clank. Actually, I think the original testimony was that a tool was dropped, but that was stricken, and then it was referred to as a metallic clank. There was also reference to what by Officer Edwards of that it appeared Mr. Beasley was doing something to the fender. That's
Well, no, that's not testimony that he was doing anything to the fence. There's nothing on this record. He was crouched down, that's all.
It was a newer model vehicle. It was stolen. Your Honor, the people argue that there is a question of fact as to whether both Mr. Beasley and Mr. Ruff, they're in a garage they have no reasonable expectation of privacy in. There's a car disassembled. That goes to count one, operating a chop shop. With regard to count two, I put in my brief that this detached garage fits the definition of a building within the Michigan statute. And I also, subject to the arrest, Your Honor, and Officer Brooks, I believe, testified to that there was the property manager on the property, which I believe was admitted, although Officer Edwards did not get that testimony out. So the arrest, I would argue, is both legitimate for exigent circumstances, and that Officer Edwards heard that there was a person or persons with weapons. Even if the court doesn't accept that, there's no reasonable expectation of privacy, as the property owner testified that he owned the premises and that no one but Marcus Smith, his employee, his property manager, had permission to be on the premises. So even if the court doesn't accept the probable cause with regard to the auto, there is definitely a legitimate means for arrest for trespassing. And then there's the search incident to arrest of Mr. Beasley, where items were recovered and then later tested to be found to be controlled substances. So the people ask that this court find Mr. Beasley and Mr. Ruff over as charged.
Any argument?
We believe that there was illegal search that was done here. Obviously, the person that needed to be here was Marcus Smith. He never appeared. He's the one that had permission. He's the one that we have no record they ever made a phone call to the police. Secondly, we believe there's insufficient evidence as a matter of law, not question of fact, but as a matter of law, to the elements of operating a chop shop as to count one. Court knows the statute, but there's got to be a showing of any removal, specific removal of any major component part that hasn't been shown here. And the break and entering, Your Honor, the underlying offense is noted in the information is with the intent to commit the crime of operating a chop shop. There's no showing that there was any intent on anyone that was inside that location to do that. So we believe there's insufficient evidence as to count two also. As you dismiss those counts. And we believe it was an illegal entry by the police. They didn't get a search warrant. That any search conducted of my client pursuant to that illegal entry should be suppressed as fruit of the police's truth. Thank you.
For the record, Judge, I adopt the comments of my co-counsel. And also indicate to the court that there is no showing of the elements with regard to Mr. Ruff. Even based on the prosecutor's argument here at the end. And also, at best, there's a show of mere presence. So I'd ask the court to dismiss this case as to Mr. Ruff. Thank you.
Yeah, as a rebuttal, I'm just going to read my motion. It's less than really a page.
I've read your motion.
I know.
I don't need you to read. I don't need you to reread a motion I have sitting in front of me. I don't need that.
Can I make it part of the record then?
It's already part of the record. You made it part of the record when you filed it. They made it part of the record when they didn't object to it, because I generally wouldn't allow you to make argue on it. Because you filed it this morning, which gave them no notice. But they wanted to go forward with it anyway. So I have it, I read it, I understand it.
And Your Honor, I would say that both the United States Supreme Court and the Michigan case law through the Court of Appeals both indicate that there's no reasonable expectation of privacy of a trespasser in a garage. There just is no constitutional violation of either Mr. Beasley or Mr. Ruff's rights. The property owner was actually here and testified. He was calling the police for help.
He didn't call the police.
There's no.
He didn't call the police.
I misspoke. He directed his property manager to call the police.
And we don't know if he did or he didn't.
So the people believe there's no constitutional violation of either Mr. Beasley or Mr. Ruff's rights, and ask this court to bind over. Thank you.
All right. Court having heard the testimony, arguments, findings, and power, first heard from Officer Xavier Brooks that on April 28, 2023, he went to 17801 McDougal in the city of Detroit. This is a private residence that upon arriving, he saw no crime being committed. He had no search warrant. He didn't even have permission to enter the property, but they did. Their focus was to the garage. It was dark. It was night when they got there. There was one street light in front of the house, the garage in the back. He approached the garage. He said it was dark inside. He heard some type of metal drop to the floor. He heard the other police officers call out something. He doesn't know what it was, so he doesn't know if they said police. He doesn't know, say, how you doing? He doesn't know what they said. He just knows he called out something, but he heard no response. He said he heard some movement inside. He then opened the door, went inside. He observed two black males, Defendant Beasley as one of them. That were crouched down. He brought Defendant Beasley out of the garage. He ran the plate through lean, that it was a stolen vehicle. Condition was passenger rear window was broken, front bumper and grille were off, front quarter panel was off, and there was a tool bag in the garage. Say anything about any tools? You didn't even know if there was any tools in the tool bag. But there was a tool bag in the garage. He arrested Lieutenant Giles. We heard from Officer Edwards, who testified at the same date, same place. They received a call regarding a person with a weapon. And received information regarding looking towards the garage area. Again, it's dark. There's no lights on. There's nothing. They arrived, they made entry. He detained Lieutenant Beasley. He saw him crouch down in the front of the vehicle. He doesn't recall how close to the vehicle it was. This is a one-car garage, and it's not open, so I assume it's not a whole lot of room in a one-car garage. He then arrested him. He then searched the defendant and found what he thought was suspected narcotics. He filled out a form, which is the first page of Exhibit 1. Form number being 230-428-0026. We heard from Mr. C, who said he's the owner of property, and he gave no one permission to be on the property. Only person having permission was Mr. Marcus Smith, that on a phone call on 4/28, he told Mr. Smith to call the police. Then we heard from Sergeant Spencer, who testified he performed preliminary analysis, which was the true narc test, which was in part 2 and 3 of Exhibit 1. And that he found, I didn't see it, I need to see it. I guess it was tested, or everything was tested positive too. So I need to see the test.
Oh, Your Honor, it's right here.
But let's look at what we actually have here. We have the police go to a location of 1780. Sorry. All right. Thank you. All right, we have the police going to the address of 17801. There's nothing on the record that said they had permission to go to that address. They did not have a search warrant. When they got there, everything is dark and quiet. Two witnesses. They approached the garage. On approaching the garage, we get from Officer Edwards, he thought he heard something drop that sounded like metallic that dropped. Someone says something out loud, don't know what it is. One of the police officers say something, don't know what it is, don't even know which officer it was, but there's no response. Officer Edwards then makes entry through the garage door that was slightly open. He says it's very dark, and he sees two people inside crouching down, orders them to stand up, their hands against the wall or show their hands. They do that. Then arrest on Mr. Beasley. Well, he didn't do the arrest. He saw the arrest of Mr. Beasley and the search. the charges here are operating the chop shop. It's not there. There's nothing there. You got, all you have is mere presence. That's it. You got them in that garage, okay, in charge with misdemeanor trespass. But other than that, there's nothing here. Even as to the drugs, you know, there's still a requirement to show, you know, chain of control. And I heard nothing about that. I heard the officer fill out a report, and at some point he gave those drugs in the report to another officer who then did a true narc test. What happened from the point that he took it to the point that it got to the other officer who did the test? I don't know. It's not on this record. But at this point, and I only have to deal with the issue of the whether or not it's illegal search. I do agree that these gentlemen didn't have standing to make that argument. So what do we have? We got two people in a garage, period. That's what we got. Trespass. We're not charged with trespass. These matters are dismissed.
Thank you, Your Honor.
Thank you, Judge.
Have your, city control.
Thank you.
Those all right?
Yeah.
Yeah.
Yours.
Thank you, sir.
Anything else from you, Kitty?
No, that's it. I think they, yeah.
You handed me this earlier? We dismissed this case today.
Oh, is this one?
Yeah, we dismissed that one.
Oh, sure.
Yes.